All right, the time is 9 o'clock straight up. I'll wait for Andrew to come back in the room. Yeah, okay.
Hi.
All right. Good morning, everyone. Welcome. My name is John Baza. I have been appointed as the hearing examiner in several of these proceedings by the Board of Oil, Gas, and Mining. We're dealing with 6 different matters today, and I am actually going to be handling 3 of them. Later on, Mr. John Rogers of the division will take over and handle the other 3. We're going to go a bit out of order in the morning based on a request from council. We will start with the matter that's dealing with the Evelyn well. So anyone in the room or online who is interested will have to know that we're dealing with agenda item 2 first, and then we'll proceed in order with the agenda item 1 and agenda item 3. Because we are dealing with the Evelyn well and this matter first, I do need to disclose that I have been appointed as a member of the Utah Trust Lands Board of Trustees. I have served in that position a little over a month now, and because this particular matter deals with a one tract that is a SITLA lease, I wanted to disclose that I'm on that board. If there are any potential conflicts or if there are objections by any of the parties, I can certainly recuse myself from this matter, but I'd like to hear from council and hear if there's any objections on this at this point.
Fred McDonald of Council with Lear and Lear on behalf of the petitioner Event of USA Inc. And we have no objection to your continuing to serve as hearing examiner in this matter, Mr. Baza.
Thank you.
Yeah, Assistant Attorney General Mr. Haynes. The division has no objections.
I know an email was set out yesterday, and I have consulted with council with Trust Lands, and they did not feel that there was any conflict if I went ahead and performed in this capacity today. So with that being said, let me go ahead and start this matter. Today is Wednesday, September 18th, 2024. This is the time and place for the hearing examiner proceedings for docket number 2024-048, cause number 132-50. This is in the matter of the request for agency action of Oventive USA Inc. for an order pooling interests, including the compulsory pooling of the interest of certain non-consenting owners in the Evelyn 4-4, 3-1-4-9-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all of sections 4 and 9, township 3 south, range 1 west, Uinta Special Meridian, Duchesne County, Utah. We're holding this hearing in an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. Before I begin, I know we have some parties in the room. Are there members of the public present who wish to comment on this particular matter?
We're not sure what we're here for.
Okay.
Yeah. I'm here regarding, let's see, number 1,
Item number 1.
the pooling all interests.
Okay.
That would be for the
Stanley well.
Stanley wells.
I believe so, yeah. It has to do with the Monson family.
We'll deal with that at the next item.
Okay.
This matter is for the other well.
Right. That's what I'm here for. So. That's it.
Okay.
Thank you.
All right. So hearing that, we don't have any respondents in this particular matter present. So let's go ahead and take appearances of council. I know you,
My mom's on there. Is that right? Margaret E. Bear Jenkins.
I do not know.
Yeah, the other one.
So you are participating in the Evelyn Well?
My mom's been dead since April 2000. And then my buddy Brian Wixom owns International Petroleum Exploration. He's been dealing with it. He's listed on his paperwork. I don't know that he's not here about it.
Do you have an objection or do you just have a comment?
What's going on? You just taking it away?
If I could, help, I'm the counsel for Ovintiv. Okay, you're saying your mother was listed as one of the decedents?
Margaret E. Bear Jenkins.
If you give me a second here.
Fred,
The
on
estate of
page-
Margaret Baird was left to me, but I lost that paperwork in a storage unit years and years ago. And Brian Wixom owns International Petroleum and Exploration here in Salt Lake Holiday, Utah.
Okay, yes, let me ask you this, okay? Again, the compulsory pooling affects people that are claiming under your mother's estate that have not leased.
Oh,
Did you execute a lease to International Petroleum?
years ago, he got all my paperwork. I'm not sure.
Okay, well, if, as long as your interest is leased, you're not affected by it. The compulsory pooling affects people who are claiming by, through, and under your mother's estate who have not leased. Okay, so if you executed a lease either to Ovintiv or to International Petroleum, then you're not adversely affected at all by this at all.
By this hearing at all.
No, those leases contain what are called a pooling clause,
Okay.
which allows the lessee to voluntarily pool the interest. This is for people who have not leased or otherwise agreed. And
Oh.
again, the estate
This was years
papers,
ago though, but
I
it
understand,
doesn't
but
matter. It's still.
as long as you executed a lease, then
Yeah.
you're not affected by this hearing, adversely affected by this hearing at all.
Okay.
Okay?
So do I have to stay?
No, you don't have to unless you want to make a comment.
No, Brian wanted to, Brian wanted my brothers and sisters to, acknowledge that I was the heir of Margaret E. Bear Jenkins.
Okay,
And his attorney's gonna handle it, I guess, or
That's-
something. So I'm gonna turn it all over to Brian. He's my,
and that's
I grew up with
fine.
him, so he's-
Again, what happens is the companies do a search of the county records,
okay,
okay? And your mother still shows up as an owner of record because there hasn't been a probate of her estate
Right.
confirming your succession.
right, that's what he wants.
So
to do.
that's why we name anybody claiming buy through under your mother's estate who have not leased,
Oh, okay,
okay? Because
Okay.
we don't know, we don't have a court order stating that you're the heir or that any of your
right, and
siblings are
that's what
heirs.
Brian wants to do.
Right,
And
right.
he just, I was in his office Friday. And he wants the affidavit of heirship filled out from.
Okay.
Yeah, okay.
I'll
have
let
to-
Mr. Wixom handle that part of it,
Okay.
but for today, you are fine. This does not adversely affect your interest at all,
Okay,
okay?
Sir, could I ask you to repeat your names?
Casey Baird, B-A-I-R-D, yeah.
Okay,
Thank
thank
you.
you so much.
Have a good day.
Mr. Brock, and some other people just entered the room. You may want to ask them if they are involved in this matter too.
Oh, okay,
So that's the Evelyn law.
Yeah, I'm approving for,
Stanley Wells.
Stanley Wells, I keep in that wrong. Yeah, okay.
Okay, I think we're back to appearances of counsel. Fred McDonald of counsel with Lear and Lear on behalf of petitioner of Ovintiv USA Inc.
Okay,
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas and Mining.
okay, thank you so much. We have declarations that have been filed from Mr. Ashley Ellison and Mr. Christopher Wall in this matter. I've read those and reviewed them with counsel for me. Oh, seated next to me is Gary White. He is with the Assistant Attorney General. And he is going to be advising me in this hearing that's happening today. So thank you so much. Oh, first of all, does the division have any concerns about these declarations or the declarants being qualified as expert witnesses?
No concerns by the.
Okay. Assuming no objections, they are recognized as experts in their particular field of expertise for this matter. Okay? So, Mr. McDonald, go ahead and have your witnesses sworn, and I'll allow you to proceed at this point.
Thank you, Mr. Baza. With us appearing virtually today pursuant to the board's September 13th order, Mr. Ashley Ellison, the senior land negotiator for Ovintiv. Mr. Ellison, would you please wait for the camera? And Mr. Christopher Wall, the reservoir engineering advisor for Ovintiv. And I would ask that they be sworn in at this time.
Please raise your right hand to the square. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, I do.
As Mr. Baza indicated, both parties, their resumes were submitted as Exhibit 1 in this matter. Both have been previously recognized as experts by the board, and Mr. Baza has already recognized them as experts in the fields of petroleum land management and reservoir engineering, petroleum engineering, respectively. The board, and by designation, the hearing examiner, have jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations found at R 649-2-8A and R 649-2-9A. A copy of the request was mailed certified mail to the known party sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and Ovintiv's internal records. It was also mailed to the Ute Indian Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, the Uinta Ouray Agency.
If you can slow down just a little bit.
Will do. And the Vernal Field Office of the Bureau of Land Management as the technical advisor to the Bureau of Indian Affairs due to the tribal mineral ownership. It was also mailed to the Utah School and Institutional Trust Lands Administration due to the state mineral ownership within the drilling unit. In addition, the notice of the filing of the request and of this hearing was also duly published in the Uinta Basin Standard on August 28th, 2024, the Deseret News on August 30th, 2024, and in the Salt Lake Tribune on September 4th, 2024. On September 10th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request. No other objections or responses to the request were timely filed. This cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 4 and 9 of Township 3 South, Range 1 West, USM in Duchesne County. As reflected on Exhibit 5, which is shown on the screen, Matt, if you would put that up. Thank you. The drilling unit is comprised of 1,277.46 acres. The drilling unit was established by the board's order entered in cause number 139-134. Ovintiv is the majority working interest owner as reflected in revised Exhibit 8 and in paragraph 12 of Mr. Ellison's declaration. A true and correct copy of the 139-134 order was submitted as Exhibit 2 in this matter. Prior to the entry of the 139-134 order, the board's order in cause number 131-51 established sections 4 and 9 respectively as sectional drilling units for Lower Green River Wasatch production. Pursuant to the 131-51 order, Harvest U.S. Holdings LLC or Newfield Production Company, both companies which were Ovintiv's predecessor by assignment, merger, and name change, drilled the wells outlined in paragraph 2 of the request for agency action, paragraph 9 of Mr. Ellison's declaration, and as reflected on Exhibit 7 in this matter. Exhibit 7 is shown on the screen. The 139-134 order expressly vacated the 131-51 order and provides that production from those existing wells would convert to the section 4 and 9 drilling unit basis on the first of the month following the first production of the first long lateral horizontal well, which is in excess of 1 mile in length, drilled on the drilling unit. In addition, any remaining non-consenting recoupment owed on the existing wells was waived as of that date. In accordance with the 139-134 order, Newfield drilled the Evelyn well at issue here with first production on April 20th, 2019. All is outlined in paragraph 5 of the request and paragraph 11 of Mr. Ellison's declaration. The conversion date for the existing wells therefore was May 1st of 2019. The general location of the Evelyn well is shown on Exhibit 5, which is on the screen. As outlined in paragraph 8 of the request and paragraph 12 of Mr. Ellison's declaration, International Petroleum Limited Liability Company is also a working interest owner in the drilling unit and has signed a joint operating agreement voluntarily pooling its interest. Furthermore, Emerald Oil and Mining Company is also a working interest owner in the drilling unit. Emerald is a consenting owner and has recently, as Mr. Ellison will testify, also signed a joint operating agreement voluntarily pooling its interest. In the request for agency action and is outlined in paragraph 14 of Mr. Ellison's declaration, Ovintiv requested that the interest of Uinta Mineral Holdings LLC be compulsory pooled and for its interest to be deemed a non-consenting owner. However, Uinta Mineral Holdings LLC has since agreed to lease to Ovintiv, and therefore Ovintiv hereby moves to amend the request to eliminate it as a party needing to be compulsory pooled and deemed a consenting party. As a consequence, Exhibit 9 will not be submitted for admission into evidence. In addition, although Ovintiv believes it has leased all successors and voluntarily pooled all their interests pursuant to the pooling clauses contained in the leases, there may be additional parties claiming by, through, or under certain decedents as identified in paragraph 16 of Mr. Ellison's declaration, whose estates have not been probated in Utah or are incomplete in distribution of the subject mineral interests. Pursuant to the board's order entered on August 15, 2024, the requisite notices of opportunity to participate were provided to them by publication on August 28th and September 4th, 2024. No responses to those notices were timely received. Replacement Exhibit 13 in this cause is a true and correct copy of the affidavit of publication of those notices received from the Uinta Basin Standard. As reflected on Exhibit 14, I'm showing the last page on the screen, and in paragraph 21 of Mr. Ellison's declaration, the average weighted fee landowner's royalty as of the date of spud of the Evelyn well is 17.718524%. As outlined in paragraph 22 of Mr. Ellison's declaration, the parties shown on the certificate and supplemental certificates of service filed in the cause are all of the production interest owners in the subject drilling unit. Their names and addresses were derived from a 2011 title opinion as supplemented by the record search by Ovintiv's contract landmen and Ovintiv's internal records. Given Uinta Mineral Holdings elimination as a compulsory pooled party, Exhibit 18 is no longer needed and will not be submitted for admission into evidence. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Ovintiv moves to enter an order of default against them, and I ask that the hearing examiner rule on that motion at this point.
I agree.
Granted, thank you. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Evelyn well is $75,000. Exhibits 16 and 17 and paragraph 7 and 8 of Mr. Wall's declaration outline the risks assumed at the time of the spud of the Evelyn well. With that, I'll commence a brief examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, sir. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
Current position with Ovintiv and its relation to this drilling unit?
Yes, sir. I'm a senior land negotiator, and we just kind of split up the DSUs. So I'm over this DSU, I guess.
All right. For the record, would you please state the corporate and bonding status of Ovintiv?
Yes, sir. Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production, Inc.
All right, Mr. Ellison, would you confirm for the record that exhibits 3 through 12 and 14 were prepared by you or Oventive personnel or contractors with your review and input?
Yes, sir, they were.
Would you also confirm for the record you have read and confirmed all the statements made in your declaration are true and correct?
Yes,
Or-
sir. Oh, I'm sorry. Sorry, Fred.
Right, are any modifications required to that declaration?
Only that I've been in touch with Emerald Oil, and they have recently sent a joint operating agreement for that interest.
And also that Uinta Mineral Holdings has executed a lease in favor of Oventive or is agreed to lease?
Yes, they have agreed to lease, and that's why we changed that page of the exhibit.
Okay, referring to Exhibit 12, is it your expert opinion that the terms and conditions of the joint operating agreement submitted as that exhibit are fair and reasonable and consistent with those executed by International Petroleum and Emerald Oil with respect to this drilling unit, as well as those commonly accepted by industry in the Uinta Basin with respect to horizontal well operations?
Yes, sir, that statement is correct.
Mr. Boswell, with that, that concludes my examination. Mr. Ellison, if you or the division have any further questions for him at this time.
Okay, let me understand a minute. If I hear what you're saying, so Uinta Mineral Holdings has leased.
Yes.
They have not leased yet. I have been in multiple discussions with them. They own minerals throughout the basin, so we are working on an expansive lease. So it is my understanding that, and we have, both sides have agreed to lease, and we are simply working on the nuances of that lease. But they have fundamentally agreed to lease this interest, which is why we have removed them from the force pool.
So under Exhibit 8, where you show the compulsory pooled interest, does that interest then change?
If again, we filed a revised Exhibit 8 to account for that Uinta Minerals situation, as well as, I believe, the Emerald. Is that correct, Mr. Ellison?
The participate Emerald and International Petroleum are the entities that make up the participating owners number. And then the compulsory pooled interest number, there used to be a small percentage in there for Uinta Mineral Holdings interest. That has been removed, and that's why the estates is the only thing in that box, basically.
And does the state box that gets filled in after probate and all that?
If there's any party that is claiming buy through or under those estates that have not leased, then that would be modified and changed to account for that. But at this point, we're not aware of anybody.
Okay. Understood. Thank you.
Sure.
Mr. Haynes, do you have any questions from the division?
Just one question. So I believe you indicated that the names and addresses were pulled from a 2011 title opinion. Was there any need to update that title opinion for more current addresses or for the deceased parties, or was that done in-house? How have you since then?
Yeah, it's a great question. 2011 is a long time ago. So we very much needed to update addresses. We have a company, Lone Wolf Energy. They do a lot of our address updates. So they work diligently to notify the correct people with correct addresses of today's date from recent information.
Okay. Yeah, no further questions from the division.
Okay. I think you have another witness to take care of,
I
right?
do. Thank you, Mr. Boswell. With that, I'll commence my examination of Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Yes, it's Christopher Wall, 4 Waterway Place Drive, Suite 100, The Woodlands, Texas, 77380.
All right, what's your current position with Oventive and its relation to this drilling unit at issue?
Yes, I'm a reservoir engineering advisor with Aventiv with jurisdiction over this GSU as well as others in the Uinta Basin.
All right, would you confirm for the record that exhibits 15, 16, and 17, these are shown on the screen, were prepared by you or Aventiv personnel with your review and input?
Yes, that is correct.
All right, have you read, and can you confirm for the record that all the statements made in your declaration are true and correct?
Yes, they are correct and true.
Do you need to make any modifications to that declaration at this time?
I do not.
All right. Is it your expert opinion then that the actual cost of the Evelyn well as at issue reflected in Exhibit 15 were fair, reasonably, and necessarily incurred?
Yes.
All right. Is it also your expert opinion that the Evelyn well was economically feasible to drill as that term is utilized in the 139, 134 order?
Yes.
Finally, is it your expert opinion that the risk shown and outlined on Exhibits 16 and 17, particularly the drilling and operational challenges actually incurred with respect to the Evelyn well, justify the imposition of a 300% risk assessment award and is fair and reasonable under the circumstances?
Yes.
All right, Mr. Bob, that concludes my examination. Mr. Wall, if you or the division have any questions at this time.
I only have one question of Mr. Wall, and it has to do with the fact that I have a technical background. I'm curious about the explanation for the drilling and operational challenges on this particular well. I noticed that the costs seem to be a little higher than the average well, but I can see that you explained that there's a hull collapse and high treating pressures during operation. Can you go into a little more detail and tell me about those a little bit?
Sure. So while we're drilling this well, the hull collapsed as we were changing out our bit, and when we went back in, we couldn't continue to drill. So at that time, they decided a sidetrack was the better way to go, and that incident there cost an extra $1 million on the drilling side. And then, you know, the completions team didn't anticipate the pressures that they did see. And it just elongated the amount of time that we had to pump on location, which just drives up your cost because we do pay essentially by the hour for the pumping equipment.
So those high treating pressures, is that a function of the rock properties or just harder to frack, that sort of thing?
Yeah, I think there's a number of things that could go into it, but the biggest driver is typically the reservoir itself, the properties that you mentioned, that can dictate a lot of what the pressures that we see.
Okay, thank you for that explanation. Do you have questions from the division?
The division has no questions. Well,
Okay, thank you.
That concludes our presentation in chief. Mr. Baza, at this time, I would move for admission of exhibits 1 through 7, revised exhibit 8, exhibits 10 through 17 inclusive, as well as Messrs. Ellison and Wall's declarations. And again, as a reminder, exhibits 9 and 18 are not being submitted for admission.
Mr. Hearing Examiner, Mr.
Yes.
Baza, I have a comment to make on behalf of the board. The board has not approved submission of revised exhibit 8 out of time.
Okay,
Thought they did last night.
It is not in file. And our board secretary is checking on the status of that order. But at this time, it has not been approved.
Okay, well, we could stick with the exhibit 8 as corrected by Mr. Ellison's testimony and as reflected in revised exhibit 8.
I think we'll do that. We'll go ahead and accept it by the board to acknowledge that revised exhibit 8.
Okay, fair enough.
And Mr. Haynes, I know you have previously submitted the division's response to the request, and there was no objections at the time. Do you have any questions or objections to the exhibits at this time?
oh, no objections to exhibits.
Okay, very well. We'll receive those exhibits, and again, on Exhibit 8, we'll just allow that to be pending the board's action.
Thank you, Mr. Boswell.
Okay,
I'll reserve commentary until after the division statements and closing statement.
okay.
Yeah, so just briefly, the division filed their response. We don't have any opposition to this request for agency action by Oventive. We reviewed the request, reviewed the exhibits, reviewed the declarations offered and the testimony offered here today. And the division believes that Oventive has met its statutory and regulatory guidelines for this compulsory pooling.
Sorry, regulatory guidelines for.
The statutory pooling, and we're in support.
Mr. Haynes, I see you have some individuals from the division in the room with you today. Are they here for this matter?
They're here for all the matters.
Oh, okay. And do they have any testimony to give?
We have no testimony on this.
All right, thank you very much. Well, Mr. McDonald, I guess it's time for your closing statement.
Well, thank you, Mr. Boswell. Again, under the circumstances, I believe that Oventive has met its statutory and regulatory burden. We ask that you approve the request as submitted. We believe the requested relief is fair, reasonable, and justified under these circumstances. We also thank you for your time and attention and consideration of this matter, and also to the DNR staff for allowing the virtual participation.
Yes, I'd like to thank the DNR staff as well. Very helpful in this case. I know that the matter of the compulsory pool parties has changed since the initial filing. So I don't know that there's any concern over having provided adequate notice, but I believe adequate notice was provided. They had time to elect to participate, and apparently some of them have taken that opportunity at this point. It seems that the 300% non-consent penalty is fair and justified, and I think the division has agreed that and have no objection to that. I think Oventive has met its burden of proof. So in this case, I would be prepared to give a recommendation to the board to accept the request for agency action and approve Oventive's request at this point. And those matters will be taken up at next week's board meeting. And I believe that is a remote hearing that will take place in Vernal. So many of us are going to be appearing remotely. That's when I will give the hearing examiner's recommendation. So at this point, I would say, Mr. McDonald, would you prepare the proposed order in this case?
I will, Mr. Boswell.
And I'll review that.
I'll submit to council for review and your review as well.
Yeah, and that's what.
Thank you.
Is there a comment online? Okay. All right. Is that okay with you, Mr. Haynes?
Sounds great.
All right. Great. That concludes this particular matter, and we'll move on to the next one at this point.
Thank you for your time, everyone.
Thank you, Mr. Ellison. So now we are on going back to item 1. This matter does involve the Stanley Wells. I know we have some individuals in the room who want to comment on that. So let me go ahead and read this matter into the record. Again, this is Wednesday, September 18th, 2024. This is the time and place for hearing examiner proceedings for docket number 2024-047, cause number 132-49, in the matter of the request for agency action of Oventive USA Inc. from order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the 9 Stanley series of wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations, comprised of all of sections 13 and 14, Township 3 South, Range 4 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing in an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. And before we begin, I know there's some individuals in the room. I'd like to have them introduce themselves and give us an idea of what you may comment on.
Okay. I'm David Amos. This is my brother Randy.
Everett are, officially Everett.
Okay,
And we are heirs of Gene Monson. This is our mother that died in 2002. And we have been actively engaged in leases with the different companies since, I think, probably going back, what, 2007, 2008?
At least that far,
Yeah.
maybe.
And have been involved in those leases since then, compensated accordingly. And I guess our question is, my mother was married to her second husband, Lawrence Monson, surname with a lot of the people on this on this particular opinion. And we kind of a little surprised by all of this, that their names would appear after 20 some odd years. We've been actively engaged with the leases. And so that was our question as to why the Monson family is even being considered at this point.
well, I think that Mr. McDonald may be able to address some of that during his presentation. But if I understand you correctly, since you are leased, you are probably a participating party to whoever your lessee is.
Yes, and we've had multiple companies. I think this is our third company in the last 2 years.
Right.
So,
again, as Mr. McDonald explained in the first matter we heard, because you're participating through those leases, this matter probably doesn't affect you in terms of compulsory pooling, because that's what this is all.
okay.
This is affecting those parties who are unleased or didn't have their interests committed to the unit.
So I guess our question is, are they in a position to claim ownership on this, or what's the?
Well, that, again, sir, what the problem is, evidently there hasn't been a probate yet, or we didn't discover a probate. Is it your father that was named as a decedent?
No, my mother died and left. We were the heirs to all of these different properties.
She had a family trust.
And I don't know if those were, if these particular mineral rights were included in that trust or not. There was some confusion at the time. My mother inherited it from her aunt, and I don't know that it had been properly probated at that time, so I don't know.
Well, again, the company identified the people that are listed as decedents as possible owners, okay?
Yeah.
Again, if you're not listed as one of the actual compulsory pool parties, or if you're under one of these other parties that are listed as a decedent, there's evidently hasn't been a probate of the estates of those parties to show the proper succession.
Okay.
And again, it's only as to people who haven't leased, who are claiming under those decedents, that would be compulsory pooled here. Because we don't have a conclusive order saying, yes, these are the people who succeeded to these decedents' interests. But again, if you've indicated that you've leased, as Mr. Baza indicated, this does not affect you at all because you granted a lease. The leases contain what's called a pooling clause, allowing the lessee to voluntarily pool the interest. We're only dealing with people who haven't leased or haven't voluntarily pooled their interest. So
Okay,
you shouldn't be adversely affected at all by this hearing.
Okay, that makes sense. That answers our question.
But you're welcome to go ahead and listen to the presentation.
Oh,
If you have
absolutely,
concerns
yeah.
at that point.
Yeah.
I might actually learn something. I was on vacation. I got this in the mail Friday night when I got home, and so
Well, thank you.
I'm a little bit in the dark, but
It's a complicated process.
yeah, I've noticed.
We'll try to work through it today, and hopefully if you have any questions, you should be welcome to ask.
I appreciate your help.
Thank you.
Sure.
Appreciate it. Is it Mr. McDonald?
Yes.
Thank you.
Okay. So we've got the members of the public who are here. Let's go ahead and take appearances of counsel.
Thank you, Mr. Baza. Fred McDonald, with counsel with Lear and Lear on behalf of petitioner Oventive USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas and Mining.
Thank you very much. Sorry, fingers from the. Okay, in this matter, we've received declarations from Mr. Peter Burns and Mr. Christopher Wall in this matter. Those have been filed. I've read them. We've reviewed them together, myself and counsel. Again, I probably should introduce Mr. Gary White, who is serving as counsel to me as a hearing examiner in this matter. First of all, does the division have any objections to the declarations or the declarants being received as experts in their fields today?
No objections by the division.
Okay, then let's go ahead and accept and recognize the witnesses as experts in their field, respective fields of expertise. And I can see that they're present online. So with that, Mr. McDonald, you are welcome to go ahead and proceed.
Thank you, Mr. Baza. With us in this matter, appearing virtually pursuant to the board's September 11th order, are Mr. Peter Burns, Land Advisor. Mr. Burns, please wave for the camera. And Mr. Christopher Wall, who's the Reservoir Engineering Advisor for Oventive. Mr. Wall, would you please wave your hand? And I would ask that they be sworn in at this time.
Please raise your right hands to the square. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Thank you.
As you've indicated, Mr. Baza, Mr. Burns and Mr. Wall, their resumes were submitted as Exhibit 1. You've recognized them based on that and their previous recognition as experts in the field of petroleum land management and petroleum engineering, respectively. For purposes of this, I'd like to also confirm that you received the supplement to Exhibit 21, which was filed on Monday. Those are simply the additional return receipts indicating service upon the compulsory pool parties we had valid addresses for.
Yes, we've received those things.
Thank you. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R 649-2-8A and R 649-29A. A copy of the request was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at issue at their last addresses disclosed by the relevant realty records and Oventive's internal records. It was also mailed to the Ute Indian Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, Uinta and Ure Agency, and the Vernal Office of the Bureau of Land Management as technical advisor to the Bureau of Indian Affairs due to the tribal mineral ownership within the drilling unit. In addition, notice of the filing of the request in this hearing was also duly published in the Uinta Basin Standard on August 28th, 2024, the Deseret News on August 30th, 2024, and in the Salt Lake Tribune on September 4th, 2024. On September 10th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request, and no other objections or responses to the request were timely filed. This cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 13 and 14 of Township 3 South, Range 4 West, USM, and Duchesne County. The drilling unit is shown on Exhibit 4, just for reference here. As you can see, it's comprised of tidal and fee minerals. The drilling unit was established by the board's order entered in cause number 130-23. Oventive is the majority interest owner as reflected on Exhibit 7, shown on the screen here, and in paragraph 13 of Mr. Burns' declaration. A true and correct copy of the 130-23 order was submitted as Exhibit 2 in this cause. Prior to the entry of the 130-23 order, Sections 13 and 14 were subject to the 13990 order of the board, which established sectional drilling units for Lower Green River Wasatch production. Pursuant to the 13990 order, EP Energy E&P Company LP drilled the wells outlined in paragraph 2 of the request and is designated on Exhibit 6 and is addressed in paragraph 9 of Mr. Burns' declaration. The 13023 order expressly partially vacated the 13990 order, and production from those existing wells converted to the section 13 and 14 drilling unit basis as of the first of the month following the date of the first production of the first long lateral horizontal well, which is in excess of 1 mile in length, drilled on the drilling unit. And any further recoupment owned from a non-consenting owner in the existing wells would be waived as of that date. In addition, the board expressly required Ovintiv to obtain the written consent of Javelin Energy Partners Management, LLC, which was EP Energy's successor by assignment, prior to drilling any such long lateral well. In accordance with the 130-23 order, including obtaining and providing Javelin's written consent, Ovintiv drilled the 9 Stanley wells at issue, with production from the first of those wells on July 31st, 2024, as outlined in paragraph 5 of the request and paragraph 12 of Mr. Burns' declaration. The conversion date for the existing wells, therefore, was August 1st of 2024. As outlined in paragraph 12 of Mr. Burns' declaration, Ovintiv has since succeeded Javelin as the operator of those 4 existing wells. There are 5 specific parties to be compulsory pooled and declared as non-consenting owners in the 9 Stanley wells: Ann Monson, Cartland Monson, Karen Valentinier, John Batter, and Mark Batter. As reflected on Exhibit 8 through 15 and paragraphs 15 through 20 of Mr. Burns' declaration, the requisite notices of opportunity to participate in the Stanley wells were provided to these 5 parties, but none timely responded. Their collective gross working interest in the drilling unit is reflected on Exhibit 7 as 0.1018457%. In addition, although Ovintiv believes it has leased all such successors and voluntarily pooled their interests pursuant to the pooling clauses contained in the leases, there may be additional parties claiming by-through or under certain decedents, as identified in paragraph 21 of Mr. Burns' declaration, whose estates have not been probated in Utah or are incomplete in distribution of the subject mineral interests. Pursuant to the board's order entered on August 15, 2024, the requisite notices of opportunity to participate were provided to them by publication on August 28, 2024 and September 4, 2024. No responses to those published notices were ever received. Replacement Exhibit 16 in this cause is a true and correct copy of the affidavit of publication of those notices received from the Uinta Basin Standard. As reflected on Exhibit 17, which I'm showing the last page of, in paragraph 24 of Mr. Burns' declaration, the average weighted fee land royalty as of the date of spud of the Stanley wells, they were all spud on the same day, was 17.258117%. As outlined in paragraph 26 of Mr. Burns' declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the subject drilling unit. Their names and addresses were derived from a 2023 title opinion as supplemented by a record search by Ovintiv's contract landmen and Ovintiv's internal records. Exhibit 21 as supplemented reflects the status of the certified mailings of the request to the 4 expressly named compulsory pool parties, five parties. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Ovintiv moves to enter an order of default against them, and I ask that the hearing examiner rule on that motion at this time.
I concur. Granted.
Thank you. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Stanley wells, each of the Stanley wells, is $75,000. Exhibits 19 and 20 and paragraphs 7 and 8 of Mr. Wall's declaration outline the risks assumed at the time of the spud of the Stanley wells. At this time, I'll commence my examination of Mr. Burns. Mr. Burns, please state your name and address for the record.
Sure. Peter Burns, and Oventive's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
And what's your current position with Oventive and its relation to this drilling unit as issued?
I'm a land advisor with responsibility over this drilling unit, among others.
Okay, would you please state for the record the corporate and bonding status of Oventive?
Yes, Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production, Inc.
All right, would you confirm for the record that exhibits 3 through 15 and 17 were prepared by you or Oventive personnel or contractors with your review and input?
Yes, they were.
All right, would you also confirm for the record that you've read and confirmed all the statements made in your declaration, that they're true and correct? Or if any modifications are required, please state them on the record at this time.
Yes, I believe they're all true and correct, and I do not have any modifications at this time.
All right, is your expert opinion as a petroleum land management expert that the terms and conditions of the joint operating agreement submitted as exhibit 15 in this matter are fair and reasonable and consistent with those executed by the other working interest owners in this drilling unit as outlined in paragraph 13 of your declaration, and also with those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes, I believe they are.
All right, Mr. Baza, that concludes my examination of Mr. Burns. I open him up for your questions and the divisions.
Okay. Mr. Burns, going to exhibit 7, that shows the Oventive's interest and then the compulsory pooled interest. The 0.018457% seems very small, I mean, comparatively. To
Yes.
some of the compulsory pool matters that we've looked at with the division. Being that small, it seems like in a way it doesn't justify these proceedings, but is it because we're dealing with numerous wells and the costs of those numerous wells?
Yes, I mean, this is a very small interest that we're pooling. I mean, it's less than 1/4 of an acre in total. But there are 9 new wells here, plus the 4 vertical wells that we just acquired from Javelin. So, in aggregate, this does add up over time. And so we do want to get this pooling order in place for that reason.
Understood.
And furthermore, to give these parties an opportunity to lease, we were able to lease, some of their other family members. Just these particular 5, they were non-responsive.
And since we have public participants in the room with us today, could you describe how the average weighted landowner royalty is applied to these interests?
Sure. So that the spreadsheet shows like all of the fee leases that we have taken prior to spud of the Stanley wells. It does not include any state or tribal BIA leases, but we total up the lease net acres and then use their lease royalty in a calculation to come up with a weighted average, which in this case is a weighted average royalty of 17.258117%. And so these 5 pooled parties will get that weighted average royalty in all of these 9 Stanley wells.
Right. So in a sense, what we're doing is they're forfeiting their working interest percentage during the time of recovery, but they still get a royalty percentage based
Yes,
on
that's
that.
correct.
Thank you. Appreciate that explanation.
Sure.
Do you have questions, Mr. Burns?
The division has no questions, Mr. Burns.
Thank you. Very well, then let's go ahead with your next witness.
All right, thank you, Mr. Baza. Also, just to clarify for the people in the audience, again, by statute, the state and tribal royalties under their leases are not accounted for in the average fee-weighted royalties, so that fee owners are compared to fee owners. So that's why we have that. All right, with that, I'll commence my examination. Mr. Wall, would you please state your name and business address for the record?
Yes, Christopher Wall, business address 4 Waterway Place Drive, Suite 100, The Woodlands, Texas 77380.
And what is your current position with Oventive and how does it relate to this drilling unit?
Yes, I'm a reservoir engineering advisor for Oventive with jurisdiction over this GSU as well as others in the Uinta Basin.
All right, would you please confirm for the record that exhibits 18, 19, and 20 filed in this matter were prepared by you or Oventive personnel with your review and input?
That is correct, yes.
All right, would you also confirm for the record that you have read and can confirm that all the statements made in your declaration are true and correct, or if you have any modifications, please state them at this time?
Yes, they are true and correct, and I do not have any modifications at this time.
All right, is it your expert opinion then, as an expert in petroleum engineering, that the actual costs of the Stanley wells at issue reflected in Exhibit 18, which is a 3-page exhibit, for all 9 wells were reasonably fair and necessarily incurred?
Yes,
Is it also your expert opinion that the Stanley wells were economically feasible to drill, as that term is utilized in the 130-23 order?
yes,
Finally, is it your expert opinion that the risks reflected on Exhibits 19 and 20 and as outlined in your declaration justify the imposition of a 300% risk assessment award, which is fair and reasonable under these circumstances?
yes.
All right, with that, that concludes my examination, Mr. Wall. I'll open him up to questions by you, Mr. Baza, or the division.
I don't have any questions for Mr. Wall this time. Division?
The division has no questions.
Very well, thank you.
Thank you, Mr. Baza. With that, we'll move for admission of Exhibits 1 through 15, replacement Exhibit 16, Exhibits 17 through 20 inclusive, and Exhibit 21 as supplemented, as well as Mr. Burns and Mr. Wall's declarations.
And those revised exhibits have been accepted at this point. Thank you. Those exhibits are. Oh,
Yeah, no objections.
okay. Sorry about that.
No.
Okay. All right, appreciate that. Those exhibits are accepted.
Thank you. With that, I'll reserve my closing comments until after the division's made its statement.
Okay. Division, do you have a statement to make at this point?
Yeah, just the division again, we reviewed this request for agency action. We reviewed the exhibits. We also reviewed the profit testimony by declaration, and also, based on supplemented to Exhibit 21, his all known compulsory pooled parties were probably noticed, and they have not appeared today or filed a response. So there's no objections to that based on those things. The division is in support of this request.
Okay, and that's, that was made, statements made in your response filed in this matter. So thank you very much for that. And Mr. McDonald, I think it's time for your closing statements.
Yes, thank you, Mr. Vice. I'll be very brief. Again, the statutory and regulatory requirements have been satisfied. Oventive has met its burden of proof. The requested relief is fair, reasonable, justified as provided, and we ask that you approve the request as submitted. Again, thank you for your time and efforts and consideration, and again to the DNR staff for allowing the virtual participation by our witnesses.
Thank you, Mr. McDonald. And Oventive has provided sufficient notices as evidenced here today for the opportunity to the non-consenting owners, allowing them an opportunity to participate. The testimony given and the declarations filed show that a 300% non-consent penalty is fair and justified. Oventive has met its burden of proof in this regard. And with this, I am prepared to recommend to the board to approve Openness request as filed. And with that, Mr. McDonald, I'll ask you to prepare a proposed order on that.
Certainly, and I'll submit it to council for review as well.
Thank you very much. Any other comments before we close?
Mr. McDonald.
Yes, sir.
If you have a card or something, we would like to take care of this legally to satisfy any concerns that your findings might have.
That's fine. I don't carry business cards anymore.
Yeah.
But my name and address should be on the request for agency action, if you have that.
Oh, yeah, we've got it.
Yeah, so it's at the end of that.
Yeah. I have
The
that.
big thick one that you would have received, it's on that address, and my email's on that as well. I'll be happy to assist you.
Okay, my wife and I are gonna be updating our trust. We want to make sure that this is included in that. And so would it be okay then if they contacted you for requirements that?
Yes,
we would need?
that's fine. We'll be happy. There's plenty of members in our firm that do curative matters like that, as well as estate planning.
Okay, I would appreciate it all, thank you.
Yes, sir.
Thank you to the board, in general, and specific individuals. This was interesting, and thank you for including this.
And I probably should make mention, the board hearing is next week on Wednesday. It's going to be held in Vernal. There are several of us who will participate remotely from Salt Lake, but that's when I will give my recommendations to the board for their approval.
We've got that information, I believe, in the package.
Okay. Thank you so much.
Thank you.
Well, that concludes this matter. Appreciate everyone's participation. We'll move on to item number. Does anyone need a break? Or would it be better to break after this third matter and then Mr. Rogers can take over?
If I may, Mr. Bozak, going back to the first matter, during that last hearing, we had the, Julian, go ahead.
Yes, I would like to say that, the board secretary filed the order granting, filing of the revised exhibit, and that is now.
Yes, on the first matter, the revised exhibit 8 has been admitted by the board. That came in almost after we finished.
Okay,
That's how it goes, right?
Yeah,
Yvonne was able to sign it this morning. Okay, good.
Did you need a break?
Okay,
Let's do it.
probably should. Let's take 5 minutes. We'll recommence at 10 after 10.
All right, Sandra.
Okay, agenda item number 3.
So let us, because we're coming back off of a break,
We're not, are we?
are we ready to go back on? We're not on yet. Carmen, will you, oh, we are live. So whenever you're ready, Mr. Baza, you may proceed.
Court reporter, are you okay?
Yeah.
All right. Let's go ahead. Good morning again. My name is John Baza. I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, September 18th, 2024. This is the time and place for the hearing examiner's proceedings for docket number 2024-051. Is that right?
Correct.
Okay. Cause number 132-53 in the matter of the request for agency action of Oventive USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Sandra UT 16-7, 4-2-17-29-7HX well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations, comprised of all of sections 17, 20, and 29, Township 4 South, Range 2 West, UN Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. And before we begin, I'm looking around the room for members of the public who may be participating, and I'm not seeing any at this point. So let's move forward to appearances of counsel.
Fred McDonald of Counsel with Lear and Lear on behalf of petitioner Oventive USA Inc.
Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. And we've received declarations from Mr. Peter Burns and Mr. Christopher Wohl in this matter, and we reviewed them before the hearing. Does the division have any objections to these declarations or the declarants being qualified as expert witnesses?
No objections by the division.
Okay. With that, the witnesses are recognized as experts in their respective fields of expertise for this matter today. And I can see that they're online, ready to participate. Therefore, Mr. McDonald, go ahead with your presentation.
Thank you, Mr. Baza. With us for this matter, appearing virtually pursuant to the September 13th board order, are Mr. Peter Burns, Land Advisor, and Mr. Christopher Wall, Reservoir Engineering Advisor. And I ask that they be sworn in at this time.
Please raise your right hand to the square. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes.
Thank you.
Thank you. As Mr. Baza has already indicated, Mr. Burns and Mr. Wall have been recognized as experts in the fields of petroleum land management and petroleum engineering for purposes of this cause. The resumes were submitted as part of Exhibit 1, and again, they have been recognized as those experts in those fields on many occasions by the board and other hearing examiners. I'd like to confirm that you received the supplement to Exhibit 32 filed on Monday. Again, that's just the update of the return receipts for the postal inquiries on the status of the mailings to the compulsory pool parties.
And seeing that the board secretary has shown those.
All right, thank you. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations at R 649-2-8A and R 649-2-9A. A copy of the request was mailed certified mail to the known parties sought to be compulsory.
Just a second.
Okay.
You good? Did
Okay.
you get that through that part or not?
You want to repeat it? That's
All right,
great.
let's start again.
I do not know what that was, but I will keep my ears out and try and solve it if it comes back.
Again, a copy of the request was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all the other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and Oventive's internal records, and to the Ute Indian Tribe, Ute Distribution Corporation, the Bureau of Indian Affairs, Uinta and Ure Agency, and the Vernal Field Office of the Bureau of Land Management, which serves as the technical advisor to the Bureau of Indian Affairs due to the tribal mineral ownership within the drilling unit. In addition, notice of the filing of the request in this hearing was also duly published in the Uinta Basin Standard on August 28th, 2024, the Deseret News on August 30th, 2024, and in the Salt Lake Tribune on September 4th, 2024. On September 10th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request, and no other objections or responses to the request were timely filed. I would, okay, and this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 17, 20, and 29 of Township 4 South, Range 2 West, Uinta Special Meridian in Duchesne County. As reflected on Exhibit 4, Section 29 is a partial section due to the Uinta Special Meridian serving as its southern boundary. The drilling unit is therefore in this cause comprised of 1,581.60 acres. The drilling unit was established by the board's order entered in cause number 130-14 as reflected in revised Exhibit 8, which has been admitted by the board or allowed to be filed. Oventive is the majority working interest owner. This is also set forth in paragraph 17 of Mr. Burns' declaration and will be modified in his testimony. A true and correct copy of the 130-14 order was submitted as Exhibit 2 in this matter. Prior to the entry of the 130-14 order, Section 17 was not spaced, while sections 20 and 29 were subject to the board's 266.01 order establishing 40-acre or substantially equivalent drilling units for Green River Formation production. As outlined in paragraph 2 of the request, paragraph 9 of Mr. Burns' declaration, and as reflected on Exhibit 7, Newfield Production Company, Oventa's predecessor by merger and name change, drilled the identified existing wells. Production allocation for the Section 17 wells was on a wellbore basis pursuant to the rule of capture, while production allocation from the other wells was on the 40-acre or equivalent drilling unit basis under the 266-01 order. As outlined in paragraph 11 of Mr. Burns' declaration, under the board's 266-02 order, all interest in the respective drilling units within the west half of Section 20 and lots 3 and 4 in the north half northwest quarter of Section 29 were compulsory pooled, and one party was declared as a non-consenting owner in the 3 moon wells within Section 29. The 130-14 order expressly vacated the 266-01 and 262-02 orders and provided that production from the existing wells would convert to the 3-sectional drilling unit basis on the first of the month following the date of first production of the first long lateral horizontal well in excess of 1 mile in length drilled on the drilling unit, and any further recoupment owed from a non-consenting owner in the existing wells would be waived as of that date. In accordance with the 130-14 order, Oventive drilled the Sander well at issue with production on first production on September 21st, 2023. All is outlined on paragraph 8 of the request and paragraph 15 of Mr. Burns' declaration. The conversion date for the existing wells was therefore October 1st, 2023. The general location of the Sander well is shown on Exhibit 5, shown on the PowerPoint as well. As outlined in paragraph 17 of the request and paragraph 17 of Mr. Burns' declaration, numerous other working interest owners in this drilling unit have executed joint operating agreements. JFA Consulting LLC and Windcrest Energy LLC signed authorities for expenditure to participate in the well, but are still in negotiations with Ovintiv on the terms of a joint operating agreement. For purposes of this cause only, Ovintiv is deeming their interest as voluntarily pooled, but reserves the right to compulsory pool their interest, including imposition of a joint operating agreement if and as necessary in the future. There is also another working interest owner which has signed an authority for expenditure for the well, but which has refused to sign a joint operating agreement, which I will separately address shortly. There are 11 specific parties to be compulsory pooled and declared as non-consenting owners in the Sander well. These are Community Minerals LLC, David Pitt, Jeff Nakora, Kate S. Fowler Markham, Catherine Rowe, aka Catherine McClarty, Lacey Scott, Mary Ellen Slemaker Bennion, Monette Tapia, aka Monette Lee Noble, Tracy Brown, Tracy Lee Markham Sherrill, and Uinta Mineral Holdings LLC. As reflected in Exhibits 9, 10, 12 through 17, 20, and 22 through 24, and paragraphs 19, 20, 22 through 27, and 30 through 32 of Mr. Burns's declaration, the requisite notices of opportunity to participate in the Sander well were timely provided to all of these parties except Tracy Brown, but none timely responded. As addressed in paragraph 23 of the request, paragraph 29 of Mr. Burns' declaration, and as reflected in replacement exhibit 27, Tracy Brown was provided her notice of opportunity to participate in the Sander well by publication, but she too timely failed to respond. As addressed in paragraph 28 of Mr. Burns' declaration, subsequent to the filing of the request, Phoenix Capital Group Holdings LLC executed an authority for expenditure for the Sander well and executed a joint operating agreement, thereby voluntarily pooling its interest. As a consequence, Ovintiv moves to amend the request to eliminate Phoenix as a compulsory pool party and also as a non-consenting party. And Exhibit 18 that was submitted in this matter will not be submitted for admission into evidence. In addition, since the request was filed, Deaton Investments has leased to Ovintiv. As a consequence, Ovintiv similarly moves to amend the request to eliminate Deaton as a compulsory pooled party, and Exhibit 11, which was submitted previously, will not be submitted for admission into evidence either. In addition, although Ovintiv believes it has leased all such successors and voluntarily pooled their interests pursuant to the pooling clauses contained in those leases, there may be additional parties claiming by, through, or under certain decedents, as identified in paragraph 33 of Mr. Burns's declaration, whose estates have not been probated in Utah or are incomplete in distribution of the subject mineral interests. Pursuant to the board's order entered on August 15, 2024, the requisite notices of opportunity to participate in the Sander well were provided to them by publication on August 28, 2024 and September 4, 2024. No responses were timely received to those published notices. Replacement Exhibit 27 in this cause is a true and correct copy of the affidavit of publication of those notices received from the Uinta Basin Standard. As reflected on Exhibit 28, I'm showing the last page of that here, and in paragraph 38 of Mr. Burns' declaration, the average weighted fee landowner's royalty as of the date of spud of the Sander well is 16.755097%. As outlined in paragraph 27 of the request, paragraph 39 of Mr. Burns' declaration, and is reflected in Exhibit 25, Angel Resources 2, it's Roman numeral 2, LLC, executed an authority for expenditure for the Sander well, but objected to the terms of Ovintiv's proposed joint operating agreement. However, it failed to outline the specific objections and alternate provisions to address them, and never timely filed a request for agency action to validate its objections as required on Utah Administrative Code R 649-2-8A, subparagraphs 4.2 and 4.3. Its interest must therefore also be compulsory pooled, but it is deemed a consenting owner here. In that situation, we are simply asking for imposition of the proposed operating agreement by Ovintiv. As outlined in paragraph 41 of Mr. Burns' declaration, the parties shown on the certificate of service filed in this cause are all the production interest owners within the drilling unit. Their names and addresses were derived from a 2023 title opinion as supplemented by the record search by Ovintiv's contract landmen and Ovintiv's internal records. Exhibit 32 is supplemented, reflects the status of the certified mailings of the request to the expressly named compulsory pooled parties. As the record will reflect, none of the parties identified in the request as being compulsory pooled and or declared as non-consenting owners in this cause timely filed a response or have otherwise made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Ovintiv moves to enter an order of default against them, and I ask that the hearing examiner rule on that motion.
Yeah, I'll grant that.
Thank you. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Sandra well is $75,000. And as it represented on exhibits 30 and 31, and is addressed in paragraph 7 and 8 of Mr. Wall's declaration, the risks assumed at the time of the spud of Sandra well are outlined in those exhibits and in that declaration. With that, I'll commence my examination of Mr. Burns. Mr. Burns, will you once again please state your name and business address for the record?
Yes, Peter Burns, and Ovintiv's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
And what is your position with Ovintiv in its relation to this drilling unit at issue?
I'm a land advisor for Ovintiv with responsibility over this drilling unit, among others.
All right, would you please state for the record the corporate and binding status of Ovintiv?
Sure. Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Ovintiv Production, Inc.
All right, Mr. Burns, would you please confirm for the record that exhibits 3 through 7, revised exhibit 8, exhibits 9, 10, 12 through 17, 19 through 24, 26, and 28 were prepared by you or Ovintiv personnel or contractors with your review and input?
Yes.
You also confirm for the record that exhibit 25 is an official business record of Ovintiv?
Yes.
All right, would you also please confirm that you've read and confirm all the statements made in your declaration are true and correct, or would you please state any modifications if required at this point?
Yes, so I believe it is true and correct with a couple of modifications. As Mr. McDonald mentioned, we need to dismiss Deaton Investments, which is paragraph 21 of the declaration, as well as Phoenix Capital Group Holdings, which is number 28 of the declaration. Both of those parties need to be dismissed. And then on, I believe it's exhibit 8, the working interest summary. After we submitted this revised exhibit 8 is when we got in the Deaton Investments lease. So we need to revise these percentages slightly to accommodate that. So the Ovintiv's working interest is now 94.400968%. The non-op working interest under or pending JOA does not change, and neither does the consenting non-op working interest with no JOA. The compulsory pooled interest does change to 0.199379%. And that equates to roughly 3.15 net acres in this unit.
Okay. In your expert opinion, then, as an expert in petroleum land management, are the terms and conditions of the joint operating agreements submitted as exhibits 24 and 26 fair and reasonable and consistent with those executed by the other working interest owners in this drilling unit as outlined in paragraph 13 of your declaration? And though, with those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations.
Yes, I believe they are.
Mr. Baza, that concludes my examination of Mr. Burns. I'll open them up for questions for you and the division.
Mr. Burns, going to your revised Exhibit A, I understand you're going to need to change this again, but the consenting non-op working interest, no JOA. I believe Mr. McDonald described that as a function of this angel.
Yes, that's correct.
That they have objected to the JOA, but they haven't.
Correct. Yes, they elected to participate, signed the AFE, and then just said they did not, agree with the JOA, but did not outline any specifics or provide any, specific changes to the JOA. And so that's why we're seeking for the board to impose this JOA via the forced pooling.
Okay, understood. Thank you. I have a question on Exhibit 22, but that's not this witness.
Exhibit 22.
It's a survey plot of the well.
Yes, he did prepare it, but I do not have that on a PowerPoint.
Okay. Do I ask him?
Yeah, you can ask him.
Okay. Mr. Burns, on Exhibit 22, which is a survey plat of the well, there's some terminology on there which I'm not that familiar with. For example, it says where the surface hole is, where the kickoff point is, and then it describes something called a first take point. Can you tell me what that means?
Sure. The first take point is just like our first, first frac where we land the heel of the well, in order to, land at the setback so that we have the most productive interval that we can get within the DSU.
So does that mean that the entire productive interval for the well is still within the DSU at this point?
Yeah. Yes.
Okay, appreciate that. That's all my questions for Mr. Burns. Mr. Haynes, do you have questions for this
Sure.
witness?
Just going back to the Angel JOA, I noticed that we have a JOA for the other parties and then the Angel JOA. Do you briefly describe how those two different? Did you negotiate preliminary changes, or are they the same? How are those two JOAs different?
I mean, the JOAs that the other working interest owners have signed is no different than what we've proposed to Angel. And like I said previously, they have not proposed any specific changes. They're just opposed. So, without knowing those specific changes, it's hard to, negotiate any form that we can both agree on.
So with the two JOAs attached to the request, Exhibit A and Exhibit B, are they similar then?
Yes.
The other question is just to do with JFA and Windcrest. You indicate in your testimony that you believe they'll both sign. Has that progressed any further than when you entered that testimony, or is it the same place?
It's progressed a little bit. I mean, we're still in communication, trying to work through these negotiated terms. I am hopeful that we can get to an agreement and get this signed. Both parties are fairly motivated to get that done. So I am hopeful that we can reach an agreement.
All right, so you're fairly confident they don't need to be included as the non-participating party without a JOA, or?
Right. I would not treat them the same as Angel.
Okay. Yeah, that's all the questions we have for this first.
Okay, I have a follow-up question after Mr. Haynes then. So in terms of imposing a JOA on Angel, which JOA are we talking about? Because there's one on exhibit 24 and one on exhibit 26.
It would be exhibit 26. That's
Okay.
the one that was submitted to Angel for consideration, and that's the one that they said they had objections to, but then never followed up on.
So when we make a recommendation as a hearing examiner, we will be telling the board we want them to impose exhibit 26 on Angel.
On Angel, and the other one on the other parties that are non-consenting parties and compulsory pool that are named.
Okay, I understand. Thank you. I think that's it for this witness.
Moving on to my examination, Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Yes, Christopher Wall, business address 4 Waterway Place Drive, Suite 100, The Woodlands, Texas 77380.
And what's your current position with Ovintiv and its relation to this drilling unit at issue?
I am a reservoir engineering advisor with jurisdiction over this DSU as well as others in the Uinta Basin for Ovintiv.
All right, would you please confirm for the record that exhibits 29, 30, and 31 shown on the PowerPoint, were these prepared by you or Ovintiv personnel with your review and input?
Yes.
All right, can you also confirm for the record that you've read and confirm all the statements made in your declaration are true and correct, and that if you require any modifications, please state them at this time?
Yes, they are true and correct, and I do not require any modifications at this time.
All right, in your expert opinion, as an expert in petroleum engineering, is it your expert opinion that the actual cost of the Sandra well as reflected in exhibit 29 were fair, reasonably, and necessarily incurred?
Yes.
Is it also your expert opinion that the Sandra well was economically feasible to drill, as that term is utilized in the 130-14 order?
Yes.
It is also your expert opinion that the risk shown and outlined on exhibits 30 and 31, especially given the drilling and operational challenges actually incurred, justify the imposition of a 300% risk assessment award and is fair and reasonable under these circumstances?
Yes.
With that, Mr. Bosler, that concludes my examination, Mr. Wall.
Okay. Thank you, Mr. Wall. One question for you. Again, this goes to your exhibit 31 and probably relates back to the costs associated with exhibit 29. There were some drilling and operational challenges and increased costs. Could you describe what those challenges were and how that affected the total well cost in the end?
Sure. So, as you can see on some previous slides, this is an extended DSU. So in other words, it's a little bit longer than our typical 10,000 foot lateral. In addition to that, we did have, we started off lease, I suppose is the way to say it. So larger step out with a longer lateral. And this is about as shallow of an interval that we drill within our position. So not having done that before, I think drilling, had some challenges in front of it that it just happened to occur. So we had some extra motor failures that we didn't plan for, most likely due to the drilling environment that we were under. And then, outside of our control, there were some completion problems due, primarily to the contractor that we used, but there were some that were possibly preventative that have occurred, namely just getting water to the location in a timely manner.
Thank you. Appreciate that explanation. Mr. Haynes, do you have questions for Mr. Wall?
Yeah, just to follow up. I noticed that this well was spud in January of 2023. First production was in September 2023. Is that a typical time frame, or was that delayed because of these operational challenges that you've already addressed?
I don't think that's very typical, and I think it had to do one with some marketing, being able to move the barrels when we wanted to. But yes, certainly some of the challenges, we had to wait a bit on the completion. We drilled it and then had to wait a few months to actually complete it. So not directly related to specific equipment problems, but definitely had to wait for the market to be there, both on the operations side and the oil marketing side.
All right, thank you. That's all.
Okay, I think we're concluded with this witness.
All right, thank you, Mr. Baza. With that, I would move for admission of exhibits 1 through 7, revised exhibit 8, exhibits 9, 10, 12 through 17, 19 through 26, replacement exhibit 27, exhibits 28 through 31 inclusive, and 32 as supplemented, as well as Messrs. Burns and Wall's declarations. And again, pointing out that exhibits 11 and 18 are not being submitted for admission due to the fact that Deaton Investments leased and Phoenix signed a JOA and an AFE.
Any objection?
Objection.
Thank you.
Which one? Revised exhibit 8. Yeah, I believe I said that.
Are you going to file a second revised exhibit 8?
I can if the board wants a correction on that. Again, that just occurred. I didn't want to file another one last night. But I can do that. But the revised exhibit 8 with Mr. Burns's clarification and testimony should be sufficient for the record.
Second. Okay. You could file another revision before the board hearing.
Be happy to do that as well.
Thank you.
All right, with that, I'll defer my closing statements till after the divisions make its statement.
Okay. Turn time over to you, Mr. Hans.
Thank you. Yeah, as indicated in the division response, we have no additional opposition to this request. Then based on the testimony provided today through the declarations and in person, as well as based on supplement exhibit 32, where it appears that all known compulsory pool parties will be properly noticed and are here to object or file objections, the division is in support of this request.
Okay, thank you. Mr. McDonald, I guess it's your turn for closing.
Thank you, Mr. Baza. Again, we believe that the statutory and regulatory requirements have been satisfied. Oventive has met its burden of proof. We believe the request is fair and justified under the circumstances, and we ask that you approve it as submitted with the changes of Deaton and Phoenix. And again, we thank you for your time and effort in listening today, and also to the DNR staff for allowing for the virtual participation.
Thank you. So in closing, the request for agency action exhibits and all the evidence provided adequate information today for me to say that I find that Oventive has provided sufficient notices of opportunity to participate to the non-consenting CP owners and those owners identified in the RAA to not timely elect to participate in the well, other than the revisions that we've already talked about. I find that the 300% non-consent penalty is fair and justified, given the associated risks and the economic and geologic conditions present on this well. I find that Oventive has met its burden of proof to show that it's entitled to forced pooling of the named interests. So these are the recommendations I'll be making to the Board of Oil, Gas, and Mining at their coming hearing on Wednesday. And Mr. McDonald, would you please prepare proposed order?
I will, Mr. Baza, and I will also submit it to council for review and approval.
Thank you. Any other questions or comments before we close? If not, thank you so much. This matter is closed. And I'll turn it now over to Mr. Rogers for the next several matters. And hopefully it goes smooth and leaves that. Thank you so much.
Thank you all very much.
Thank you. I'm not sure that we need a break. You can decide then.
You need much time to.
As long as we can make sure it's working, it should be okay.
Hang on, take a time now. It's right there.
Thanks, John. Have a good one.
Good morning and welcome. My name is John Rogers. I'm an environmental manager of the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, September 18th, 2024, and this is a time and place for the hearing examiner's proceeding for docket number 2024-052, cause number 132-54. In the matter of the request for agency action of Ovintiv USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Fitzgerald, Utah 9-35-4-2-2-11-1H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all of sections 2 and 11, townships 4 South, range 2 West, USM, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank division staff, legal counsel, petitioners, and department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents that wish to comment on these proceedings? I see we have one. Do you wish to say anything? Or
An interested member of the public.
okay, thank you. Like the records show, there is no public respondents or present. We will take appearance of counsel this time. Vintage?
Thank you, Mr. Rogers. Mitch Mayo with Lear & Lair PLLC on behalf of the petitioner Ovintiv USA, Inc.
Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
My counsel is Gary White of the Attorney General's Office. I received declarations from Mr. David Dale, manager, Rockies Land for Ovintiv USA, and Mr. Christopher Wall, a reservoir engineer and advisor for Ovintiv USA for this matter, and I've reviewed them before this hearing. Both these witnesses have been accepted as expert witnesses for past hearings. Does the division have any objections to these declarations or these individuals being accepted as expert witnesses? Okay. They are recognized as expert witnesses in their particular field of study and work for this matter. Mr. Mayo, are these witnesses present today, and can we swear those in at this time?
Yes, they are, and that would be appropriate. Maybe have the witnesses sworn in when you're ready.
Please raise your right hands to the square. Mr. Dale, can you hear us?
Yes.
Please raise your right hand to the square.
David?
It's up and
I wonder if
He must.
his, I think is coming in slow. Because Christopher, you can hear us and
Sorry, my right hand is raised.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
yes.
Thank you.
We're gonna have to wait a minute to hear him say I do, but it's kind of.
Yeah, his feed's a little. At some point, we can maybe have him rejoin the meeting and see if that fixes things.
He's the first up, so if you want to do it now,
Yeah,
it
well,
probably
we
makes
do
sense.
that now.
Plus, he's on mute.
Okay.
He's trying to talk to us, and we can't hear him.
Well, I think again, Mr. Dale, your feed is delayed. Will you exit the meeting and rejoin and see if that fixes it?
Oh, that was pretty quick. I thought it was gonna take a minute. I know.
He can hear us in real time, I'm guessing.
Yeah.
I think it's just getting us back into the meeting, so.
Oh, there he is. Maybe he's got a.
Is that better?
Oh, much better. Thank you.
Very good.
Okay, so we got the swearing in. We're good there.
Mr. Dale, would you mind getting sworn in one more time? Because it was pretty glitchy, just so we've got the record complete here.
Sure.
Mr. Dale, please raise your right hand to the square. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay, we'll now proceed to Mr. Mayo for his presentation.
Thank you, Mr. Rogers. With the housekeeping items taken care of, the witnesses being sworn in and admitted as experts in their respective fields, I'd like to remind the parties here, the board and the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6.5. A copy of the request for agency action in this cause was sent by certified mail to the known parties sought to be compulsorily pooled and sent by regular mail to all other production interest owners. There was, however, a mistake made in the notice sent to the other production interest owners. You may have seen an amended certificate of mailing on file in this cause, and Mr. Dale will briefly explain that. Long answer short, they were mailed to people who had no interest in the well and then remailed to the parties who did have an interest in the well. In addition, the request was mailed to all federal and tribal agencies as relevant and applicable due to the mineral ownership within the drilling unit. In addition, notice of the filing of the request and this hearing was duly published in the Uinta Basin Standard on August 28th, the Deseret News on August 30th, and the Salt Lake Tribune on September 1st of this year. On September 10th, the division filed its notice of its response and notice of non-opposition, essentially expressing no opposition pending the presentation of evidence here today. I'd also like to remind the parties that the board designated this to a hearing examiner matter subject to there being no novel issues and no contest. And I'd like to confirm that that is the same, that is the case here today. There is no contest. Because no other parties have filed objections or responses to the request in this cause. I just got a text from Mr. Dale that was probably sent a few minutes ago saying, yes, I do. So thank you for trying to work through the technological issues, Mr. Dale. I appreciate it. Brief summary, this cause involves compulsory pooling of a unit that is 1,291.24 acres. This drilling unit was established for Lower Green River Wasatch Formation production, and it's comprised of sections 2 and 11 in Township 4 South, 2 West in Duchesne County. This drilling unit was established by board order in cause number 139-150 and is subsequently modified by board order in cause number 600-03 to reduce the heel toe setbacks. Ovintiv is the majority interest owner as shown in Exhibit 7 on file and as stated in Mr. Dale's declaration and supplemented declaration on file here. Pursuant to the current orders, a copy of which is filed as Exhibit 2 in this cause, Ovintiv spud the Fitzgerald UT 9-35 4-2-2-11-1H well, which I'll call the subject well or the Fitzgerald well, on May 5th, 2021, with a date of first production of July 19th of 2021. At the time the request was filed, and at the time the Fitzgerald well were drilled, there were no produced.
What that is. I'm going to investigate offline after this meeting, but Carmen assures me that everything's okay on the broadcast.
Okay, then I'll continue. At the time the request was filed and the well was drilled, there were no existing wells producing from the subject unit. Accordingly, conversion is provided for in the 139-150 order is inapplicable in this cause, and there's no recoupment to waive. Several owners of undivided oil and gas in the subject unit.
Slow down, please.
Oh,
several owners. Go ahead.
Several owners of undivided oil and gas interests in the subject unit and subject well have refused or failed to lease or otherwise agree to pay their proportionate share of costs of the well, including the names that appear on page 2 of the request. However, there are some corrections that have occurred, and we'll explain those in Mr. Dale's testimony. In addition, there are several estates to be pooled, as identified on page 2 of the request. Although Ovintiv believes it has leased all such successors or heirs of these estates and voluntarily pooled their interest, there may be additional parties claiming buy-through or under these decedents' estates, and accordingly, out of an abundance of caution, Ovintiv requests those estates be pooled here. I'd like to remind everyone that pursuant to the board's order entered on August 12th, August 15th. That is entirely wrong. I apologize. Pursuant to the board's order entered on August 15th, the requisite notice of opportunity to participate was provided to those parties by publication. Exhibit 20 on file is a true and correct copy of the affidavit evidencing that publication. As noted a minute ago, there are a couple corrections that are spelled out in Mr. Dale's declaration. and Mr. Dale's supplemented declaration filed last night. In particular, there are 5 named parties to be removed who have since the filing of the request leased their interest to Oventive. Those parties are Denise Christopherson, Vaughn Nelson, Vonda Harper, Joyce David, and Leroy Nelson. In addition, Oventive has seen and reviewed sufficient evidence to remove one of the estates from the pooling here, and that is the estate of Orlean Ross White, spelled W-H-Y-T-E. Aside from those parties, the remaining parties named in the request have been provided notice, have not appeared or tendered their share of costs or made an election, and accordingly are subject to pooling here today. As reflected on Exhibit 26, also on file, and is discussed in Mr. Dale's declaration and supplemented declaration, the average weighted fee landowner's royalty in the subject well to be applied here today is 18.516737%. Finally, notice was provided to all production interest owners. As mentioned earlier, there will be some explanation about that during the testimony. As outlined in paragraph 25 of Mr. Dale's declaration and the amended certificate of service on file in this cause. Finally, costs, including the plugging costs, and are just and reasonable, and the risks incurred in drilling the well justify the imposition of the requested risk compensation award. With that, I'd like to move on to the testimony from Mr. Dale, unless anyone has objection. Seeing none. Mr. Dale, can you please state your name and business address for the record?
Yes, David Dale, manager for Rockies Land, Oventives, USA Inc. at 4 Waterway Square Place, Suite 100, Woodlands, Texas, zip code 77380.
Thank you for that. And could you please state your position with Oventive generally and as it relates to this unit we're discussing here today?
Yeah, manager of Rockies Land, which would include our Uinta Basin position. And so, yeah, that asset and this unit and well in particular fall under my direction.
Okay, thank you with that. A couple things I want to hit briefly with you. Are you aware of what's been filed as the declaration of David Dale and also what's been filed as the supplemented declaration of David Dale?
Yes.
Have you seen both of these documents?
Yes.
Have you reviewed them? Are you familiar with the allegations contained in each?
Yes.
Briefly with the declaration, would it be fair to say that the supplemented declaration is solely to accommodate additional leasing that's occurred since that declaration was filed?
Yes.
Okay. Is there anything, before we move on, I'd like to address something we talked about in the introduction a little bit. There are 2 certificates of mailing in this cause of action, which is fairly unusual. Can you explain how the parties were notified originally and the amended certificate of mailing for the folks here?
Sure. Yeah, when we provided the documentation to Lear & Lear for notice for submittal, our office incorrectly pulled a division of interest from a well in Texas. We caught that, but failed to timely notify Lear & Lear to prevent that improper list going out for notification. Once that was recognized, we submitted to the correct owners under this well board. But I guess the point being made is the parties under the division of interest are royalty owners and participating working interest owners, which we already have a joint operating agreement. So they are not adversely impacted by this forced pooling. All the parties that we are in fact forced pooling did get proper and timely notice.
Okay, so the publication was timely and the mailings to the parties being pooled, those both went out timely under the rules. Is that your testimony?
Yes.
It was just the additional parties also entitled to notice who received notice slightly less than 30 days before this.
That is correct.
So that was just applicable to this request for agency action. That's what the notice. Okay, thank you.
And let me ask something there.
Yeah.
So you did send out these mailings to a well in Texas?
and I don't know if it was called a Fitzgerald well or if it was something, but there was some sort of a, David, maybe you can help.
Yeah, not quite certain how that incorrect well was pulled or why that happened. I did get personally an awful lot of inquiries from owners in Texas about the matter. But I don't know if it was a glitch in our system or just a mistake made when we were pulling the information. But we did recognize that. We have responded to all the Texas owners, and then as well as noticed the participating parties within the Fitzgerald 1H.
But it was just the additional parties to clarify.
Yeah.
Well, thank you for that clarification. With no further questions on that, I'm just going to ask you a couple summary questions. You've authenticated and said that you agree with the allegations contained in your supplemented declaration filed yesterday. Is there anything you would like to add or clarify to that, or anything new that the folks here should be aware of?
No.
Okay. So that supplemented declaration is your full and complete and accurate testimony here today?
Yes.
Okay. One last question. In your expert opinion, would you say the terms and conditions of the JOA submitted, I believe is Exhibit 25 in this cause, are fair and reasonable and consistent with what you see and enter into in the basin?
They are, yes.
With that, I have no further questions for Mr. Dale and subject to the division board.
We turn to timer division for questions.
Yeah, sure.
If you need me to pull something up.
No, it's all right. I just have a couple questions on this one. First of all, I just noticed there's a lot of deceased parties in this request. I know you don't have any control over that. That's people just refusing to probate or filing the proper documents afterwards. But just for maybe the people in the room, could you just give a brief explanation of, we have all these deceased parties, but we only have a handful of parties being compulsory pooled. How do you make the determination of who you're going to lease based on the deceased parties if you don't have their probate?
Well, if parties are deceased without any probate, we can get affidavits of heirship from them, which is a tool, it doesn't perfect the title, but it's something that we can rely upon to take a lease from someone. But if you get a title opinion from an attorney, of course, they're going to recommend that you perfect that title and get that interest probated or get it cured. And so, part of our purpose of putting them on this list is we've done everything we can. We've run their title. We've notified them. We lease the parties that we believe own to the interest that they state that they own. And so we're simply asking for protection that if they own anything more or less than what we have allocated to them, that we do in fact have that interest secured for the interest in the wellbore.
All right, thank you. Just to follow up then, in paragraph 14 of your declaration, you indicate there's a couple of protective parties being compulsory pooled. They
Yes.
are.
Farmers and Merchants Bank of Vandalia.
Yeah. Could you explain, why these parties are protected as opposed to actually being, I know they are still being compulsory pooled, but how are these parties different than the other parties?
Yeah, so I've got notes on these. So
David, maybe I can hop in real quick while you're looking at stuff. From the truth of the matter is, when you have all the estates that you have in something like this, the real answer the company should come up with today is this dead person, we need to pool them, right? That's the lawfully appropriate thing to do. And what they try and do to both help their business, but also help the ultimate owners of the interest is they do extra record searching. And that extra record searching doesn't have the necessary clarity that a lot of record title does. And so in these instances in particular, what happens is you look at a probate for someone who was dead in the 80s. In that, it has a notice filed on behalf of someone claiming an interest who's never distributed anything, but who's claiming an interest, and it's this random trust. Oventive and their title attorneys and land brokers don't believe this person's entitled to an interest, but the only way to protect the company is to include anyone who's making a claim, essentially. Does that match with what your notes are saying, David, or is there something else that I left out?
No, you're exactly right. So these would be curative parties that we don't show as owning in title. However, we aren't privy to documents that aren't filed within Duchesne County. So they're appearing in title or having claim in title somewhere. And so this is curative matters. For these in particular, you have a trust that was supposed to disperse assets upon the death of the estate owner, and that doesn't appear to have been done. You have another that where you have a claim to interest, but we have an affidavit of record stating that person was adopted, so it cannot pass through death or intestate succession. So those are the typical matters on the protective.
Okay, thank you. Thank you for that clarification.
Yeah, no, before you move on from that, I want to ask a question here. So you have a deceased party, which are many here, and they're forcefully pulled. Okay, years down the road, someone does probate and decides this is where it should have gone. Are those individuals that now are a part of this fourth pulling, they are basically given what is decided today or next week in this compulsory pulling? They have no recourse.
I mean, they could always try and appeal to the board's continuing jurisdiction to set it aside. You know, they could file a state action, I would imagine, to try and set it aside. So I don't want to say they have no recourse, but yes, the point of this is
but
if
they're
someone
either
comes
forced pulled or
forward,
they're not. Could they down the road say, we didn't want to be forced pulled and we want it back into this?
well, that everyone's entitled to that option, right?
Yeah.
To appear before the board and request that. But the short answer is yes, those parties, the point of this is anyone who shows up later down the road, they will have been voluntarily or compulsorily pooled into this unit for production. So yes, they will be pooled here today, even if they don't come forward for 20 years.
Okay. Yeah, sorry, I did one before we moved on to another subject.
Oh, no, you're fine. I just had one last question. You indicate ownership was based on a title opinion effective April 2023. Here we are in September of 2024. Before you mailed out giving notice of this proceeding today, has there been any attempt to update addresses or find a better address, I guess, for any of these parties in between those dates?
Sure. Yeah, we prior to mailing out the proposals, we do bring that title forward to all parties to make sure there's nothing filed of record that would have changed the title. And yes, we do search public and different search engine, public records and different search engines to notify these parties properly.
All right, thank you. No further questions.
Okay, Mr. Mail, your next witness.
Thank you, Mr. Dale. Stick around, but you can mute yourself for now. Mr. Wall, could you please state your name and business address for the record?
Yes, Christopher Wall, 4 Waterway Place Drive, Suite 100, The Woodlands, Texas, 77380.
Okay, and your title at Oventive and your responsibilities as it relates to this drilling unit?
Reservoir Engineering Advisor, with jurisdiction over this DSU as well as others in the Uinta Basin for Oventive.
Okay, thank you. Are you aware of what's been filed, I believe is Exhibit 31 in this cause, the declaration of Christopher Wall?
Yes.
Have you reviewed that declaration?
Yes.
And did you execute it or authorize your counsel to execute it on your behalf?
Yes.
Okay. And so you're familiar with all the allegations contained in the declaration?
Yes.
Does that declaration stand as your full, complete, and accurate testimony here today?
It does, yes.
Okay. Is there anything you would like to add to that declaration?
Not at this time.
Okay. A couple questions. You've been recognized again as an expert in petroleum engineering. Is it your expert testimony that the actual costs incurred in drilling the Fitzgerald well, as evidenced in Exhibit 27, were fair, reasonable, necessarily incurred, and within a reasonable variance of the AFE?
Yes.
Is it your expert opinion that Fitzgerald well was economic? Quote unquote.
Yes.
Thank you. And is it your expert opinion that the risks just in both the declaration and the exhibits on file justify the requested risk compensation award in this?
Yes.
With that, I have no further questions for Mr. Wall, subject to cross-examination.
Division, do you have any questions for this witness?
Just really briefly, Exhibit 27, actual cost summary. Split up into CapEx and OpEx. Access to that, Mr. Wall?
Yes, I do.
I was just curious, OpEx is indicated to be 2.2 million. You know, could you explain what that number is? Like, what would comprise that number?
So yeah, OpEx is any operating cost incurred, which would be anything from electrical expenses, chemical expenses, other producing expenses. I'm trying to think of some other ones. Workovers that are under a certain threshold would not require an AFE. Things of that nature. Those are some of the big ones.
Okay, so this well, I think first production was in July 2021. So just I don't really know, but I mean we'd be looking at about 2.2 million. Is that reasonable for wells in this area to have an OpEx that high in that time frame, or is this one higher than normal?
I don't know if I can't really answer that question because I would have to go back and look, and I haven't studied by area the OpEx. Off the cuff, it doesn't feel out of range. But this might be an area where we have to truck water as opposed to having it on pipeline, and that could tend to raise the cost because it's close to about $4 a barrel versus about $1.50 if we put it on pipe. So I might be driving OpEx here, but I'm not certain.
All right, thank you. Yeah, no further questions.
Okay. I noticed that this is the only well on the unit, correct?
That's correct.
So there would be no conversion necessary. Okay. Could we go to Exhibit 28? Okay, now I'm just trying. So we got the Fitzgerald there in 2 and 11, and below it there's another horizontal stand-up, and they seem to connect. Obviously they don't, but what's going on there?
My guess is inartful drawing, but David or Chris, can you confirm that or explain?
Are they that close?
Those wells don't touch. Is that right?
No, they're at least 200 feet apart. I don't know the exact distance, but they're at least that.
Is it safe to say they would be in the same producing interval?
They are in the same producing interval, yes.
Okay, so the scale of the map makes it look that way then, I guess.
Yeah.
Drill the 4-mile lateral. Okay, that's all the questions I have.
Thank you. At this point in time, it's probably appropriate to move for admission of exhibits. Specifically exhibits 1 through 10, exhibits 12 through 29, supplemental or supplemented exhibit 30, and exhibits 31 through 33. I'd like to move for admission of those.
Division, do you have any objection?
No objection.
So admitted.
We intentionally omitted exhibit 11 when we filed.
I see that now.
Thank you for clarifying. I'll reserve till after the division's closing remarks.
Okay. The division has filed a response and notice of non-opposition to the request for agency action dated September 10th, 2024. We alluded to that earlier. Therefore, it's my understanding that the division has no objection to the request for agency action. Is that correct? That's correct. Okay. At this time, I'll turn the division over for their presentation.
The division has no presentation. As indicated, we have initial no opposition subject to the profit testimony which we received and the testimony given today. Based on the hearing today, the division is in support of this request.
And the division is revoking, or say?
Is in support of this request.
That was a little different.
Okay, we'll take closing statements this time, and I'll go with Mr. Mayo.
Appreciate it. Same thing as usual. We appreciate everyone's time and attention to this matter. We know these are inconvenient, but it's really important work. As has been mentioned, we believe the regulatory and statutory requirements have been met and full notice has been provided to all parties who will be affected by the pooling here today. And slightly flawed notice was provided to all other parties who may have an interest herein. But clearly the notice that was mailed to the parties was effective, as there have been 5 parties who have released since the filing of the request. On that basis, I'd submit and ask the hearing examiner to approve the request as pleaded.
Okay. Division, do you have any more to add?
Nothing more.
Okay. I'd like to take a few minutes at this time to talk with my counsel, so we'll go off the record for a few minutes. Be right back. Exhibits, correct?
Correct.
Okay. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find Ovintiv has provided sufficient notice of opportunity to the consenting compulsory pooled owners, and those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that a 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, one well, and find that it's appropriate to impose the request non-consent penalty. I find though Vintive has met its burden of proof to show they are entitled to force pull the named interest and other relief requested in a request for agency action. Mr. Mayo, will you please prepare a proposed order?
I will, and I'll try and get that out to council for review by the end of the day tomorrow. So-
Okay. I then will present these findings and conclusions to the board next week at the board hearing. Any other comment before we close? If there are no other comments, thank you for your participation and we'll adjourn this proceeding.
Thank you very much.
Thank you.
We're done for the day. Thanks.
Oh, I wanted Chris to explain those calculations on the whiteboard. I'm just kidding.
On the back.
I'm just gonna hide everything in the background.
That's exactly.
Mark and Kevin, is that correct?
That's right. And they should both be on, but I've kind of given them conflicting times, so
All right. Hey, Kevin, I see you there. Can you give us a sound check?
Hey, guys, good morning.
Thank you. Wonderful. Mark, I see you as well. Sound check for you as well.
Good morning.
Okay, fantastic. Okay,
132.
we are good to proceed, Mr. Mayo.
Yeah.
perfect. Let me take 1 second to get my.
Or maybe I should say Mr. Rogers.
Yes, we'll do it on Mr. Rogers.
We are good to proceed. Our witnesses are online and they have been sound checked.
Okay, good.
And I believe we are just continuing to broadcast on YouTube. So
Everyone else ready? Okay. Here we go. Good morning, everyone, and welcome. My name is John Rogers. I'm an environmental manager at the Utah Division of Oil, Gas, and Mining and have been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, September 18th, 2024, and this is the time and place for the hearing examiner's proceeding for docket number 2024-049, cause number 132-51. In the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Company, LLC, for order pulling all interest, including the compulsory pulling of the interest of certain non-consenting and unknown owners within the 1280-acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River, Wasatch, Colton formations, comprised of Section 28 and 33, Township 2 South, Range 2 West, USM, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah.
Sorry, can you slow down just a little?
Sure. We also will be hearing testimonies and presentations in the person and virtually, and the proceedings will broadcast on the internet. I wish to thank the division staff, legal counsel, petitioners, and department technical staff to allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public respondents present that wish to comment on these proceedings? Okay. Let the record show no public respondents wish to speak. We will take appearance of counsel this time.
Thank you,
XCL.
Mr. Rogers. Thank you, Mitch Mayo of Lear and Lear PLLC on behalf of XCL Resources LLC and XCL Asset Co LLC.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
My counsel is Gary White of the Attorney General's Office. I received declarations from Mr. Kevin Anderson, Vice President of Business Development and Land, and Mr. Mark Gray, Vice President of Reservoir, both from XCL Resources for this matter, and reviewed them before this hearing. Both these witnesses have been accepted as expert witnesses for past hearings. Does the division have any objections to these declarations, or these individuals have been qualified as expert witnesses?
No objections.
Okay. They are recognized as expert witnesses in this particular field of study for this matter. Mr. Mayor, are these witnesses present today?
They are.
And we now swear those witnesses in?
Yes, that would be perfectly appropriate.
Please raise your right hand to the square. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
We'll now proceed to Mr. Mayo for your presentation.
Thank you, Mr. Hearing Examiner. As was mentioned, Mr. Anderson and Mr. Gravy are here with us today. They both have been recognized as experts in numerous causes and here today, and they will be testifying as experts in their respective causes or their respective fields, again, for this cause. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the request on file was sent by certified mail to all known parties sought to be compulsorily pooled, and also sent by regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and XCL's internal records and searching. A request was also mailed to all relevant federal and tribal agencies, to the BLM, SITLA, and DFFSL, the Forestry, Fire, and State Lands, due to mineral ownership within the drilling unit. And notice was provided to certain owners via publication as authorized by the board on August 15th, 2024. In addition, notice of the filing of the request and this hearing was also duly published in the Uinta Basin Standard on August 28th, the Deseret News on August 30th, and in the Salt Lake Tribune on September 1st. On September 10th of this year, the Division of Oil, Gas, and Mining filed a response expressing no opposition to granting the request pending the witness testimony and presentation of evidence here today. I'd like to remind everyone there were no other objections or responses to the RAA filed in this cause, and there are no members of the public here to comment or protest. Brief summary of this cause. It involves the compulsory pooling of a drilling unit established by board order in cause number 139-140, again for Lower Green River Wasatch production. This drilling unit is comprised of the entirety of sections 28 and 33, Township 2 South, Range 2 West. Cause number 130-21 entered by the board subsequently reduced the heel toe setbacks to the current 100-foot. In accordance with these current orders, XCL drilled and has begun to produce from the 9 Thing and Wild wells identified in the request. And to be clear, 5 of those wells are Thing wells, 4 of those wells are Wild wells. Several owners of undivided oil and gas interests in the subject unit and subject wells have refused or failed to lease or otherwise agree to pay their proportionate share of the costs of each of these wells, including specifically the names that appear on page 2 of the request. In addition, as addressed in paragraphs 16 and 17 of the declaration of Kevin Annenson on file, several estates are named to be pooled. XCL believes it has leased and located all successors of said estates. However, without the corresponding court order or certainty, XCL must pool the estates to protect. It should be noted that XCL provided the requisite notice of opportunity to participate to these estates and anyone claiming by through under the estates by publication as authorized by the board's order entered on August 15th in this cause. And Exhibit 13 on file is the affidavit demonstrating that publication took place. To be clear, no responses were received to the mailed or published notice. As reflected on Exhibit 8 and discussed in paragraphs 29 through 31 of Mr. Annenson's declaration, the average weighted fee landowner's royalty as of the date of spud of the first Thing Wild well is 17.285882%. And with that, I'm ready to begin with the testimony of Mr. Annenson. Mr. Annenson, can you state your name and business address for the record for me?
Sure. Kevin Annenson, VP Business Development and Land, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay, and you obviously stated your position with XCL. Can you talk about how it relates specifically to this drilling unit?
Sure. So I oversee responsibility as far as all the subsurface drilling, pooling, elections, JWAs, everything to that extent.
Okay, it would be fair to say you exercise responsibility over this drilling unit.
That's correct.
Okay. Are you aware of? Do you recognize what's been filed as Exhibit 11 in this cause, the declaration of Kevin M. Annenson?
I do. That's correct.
Okay. Did you execute this declaration or cause your counsel to execute it on your behalf?
That's correct. Yes.
And are you familiar with the allegations contained in the declaration?
I do. That's correct.
Okay, can you confirm on the record here today that the declaration, as conformed to what's been said here today and any clarifications, constitutes your full, fair, and accurate testimony in this hearing?
Yes, it does.
Okay, is there anything you'd like to add or clarify before I ask you one follow-up question?
Nothing from me.
Okay, in your expert opinion, Mr. Anderson, is the JOA submitted? Are the terms and conditions of the JOA submitted as Exhibit 7? Do you believe them to be fair and reasonable and in keeping with JOAs of similar substance you encounter in the Uinta Basin?
Yes, I do. That's correct.
Okay. With that, I'd like to open Mr. Anderson up for questions from the division or hearing examiner.
Division?
Yeah, so, um, for exhibit 14 that was filed subsequently, it's the return service or confirmation of receipt. There's a couple parts missing on there. I wonder if you could clarify that Craig Miller McFarland, Laura Twist, and Wesley Smith were sent notice of this proceeding today. Because I don't have return receipt or in that exhibit 14.
Oh, yes, they've all been sent. That's correct.
Okay.
Yes, sometimes those green cards don't always make it back.
I understand.
Unfortunately. And then some of those boxes you can't send FedEx because they won't deliver. So
I got anecdotally, I got a green card back yesterday for a cause I filed last July. So
yeah, we get that all the time, and they're like, "What's this from?" I was like, "Oh, I think that was 1.5 years ago."
but we can update with any additional returns and get that filed before the hearing if you'd like.
That's fine.
100%. Yeah, 100%. Yeah.
I just want to clarify for the record that those had been sent.
Yes, sir.
The other question I just had, I believe your affidavit indicates these wells were spud. Oh, actually, no, I do have another question too. The initial notice that went out included the Wild 71 well. What has happened to that well?
So I believe that's the other section line well. That's going to be for next month. And so what we did, it was the same owners. So for the election letters, we sent it. So like we had one section line on one side, and then we had the actual unit, and then we had a section line on the other side. So what we did is we put the 3 different packets of here's the well packets for this section line, here it is for this, and then here it is for this one over here. So instead of sending 3 different mailings, we just put it all in one.
Okay, so that one's coming at some point down the line.
That'll come next month, yes, sir.
And then the other question I had was, I believe in your affidavit indicates the wells were spud in November 2022, like March. Oh, wait, yeah. Anyway, we have spud dates for the wells. I didn't see anywhere when first production of these wells came online. Do you have that information?
I don't have it handy, but that's something that we can certainly get for you. I know Mark's he might be able to pull those up quicker than I can, but that's not a problem. We can get that for you.
Sorry to interrupt. It's included in the ex parte motion for publication.
I thought we had.
So it's in that pleading, but because these aren't conversion orders, it's mostly just curiosity, interest when they started producing, rather than it doesn't trigger anything.
I just asked for the effective date of the pooling.
Are you saying you'd like the first day of production? Sorry.
Sorry, who's talking? Mr. Green? What, would you repeat that, please?
Yeah, this is Mark Gravy. I was just making sure I was following the request. Were you asking for the date of first production?
Yes, I guess essentially when do we want this pooling date to be effective? Would this be the date of first production of the thing? Wells, I believe.
In my understanding, it's effective the date of first production of each individual well, unless this is entered before they start producing. So they'll each have a slightly different effective date, is my understanding.
That's correct. Yeah, they're all very, very close as they're all coming on in a unit under the same, like they're all coming in on the same unit right after they were getting fracked and cleaned and everything. That's correct.
Okay, so if we can just get that date, just, when we do the order, we have that in there. That's the only thing I wanted to raise on that issue.
Absolutely.
But with that, I have no further questions.
Okay, yeah, I had something similar to that. I noticed the Thing wells were all spud within a week each other on November 2022. Were there any existing wells at that time in the unit?
There was one parent well. That's correct.
So will there be a conversion in that, or how is that being handled?
No,
No.
we do not have conversion wells, no, sir.
Yeah. Oh, there's two different kind of spacing schemes, I guess, largely at play in the basin. And Ovintiv is, as I understand it, the only operator that employs the conversion scheme, where essentially, to protect themselves from frac hits internally, and because they had, as I understood it back when they presented it, such heavily developed acreage with vertical wells, it really freed them up to be able to place wells in different places by having all the existing production convert.
Okay.
For XCL, I'll speak directly, they have what I like to call the overlapping orders, and that's essentially there's a 640 order and a 1280 and a 2560, and they all still apply independently. So the wells don't convert at any point for XCL's production.
So that well will stand alone.
And even if they did, to maybe put it at ease, I believe that well was a 1280 long lateral horizontal, right, Kevin?
That's right. The 1280s, or the 10,000-foot laterals, whichever term you want to use, is all these 10,000-foot laterals are exactly the same as the other one. Obviously, interest changes, but being pulled exactly the same.
Can you please repeat that?
Oh gosh, let's see here. How did I say that? The 10,000-foot lateral, the original 10,000-foot lateral, is pulled exactly the same as all of these 10,000-foot laterals within the boundaries of this 1280.
So I guess to sum up, conversion doesn't apply, but even if it did, the existing well is already a 1280, so it wouldn't need to anyways, because it's already payable on that 1280 basis.
Will it be pulled in here?
It will not, because it was pulled previously.
But what had the pulling order in this section?
It was just before the statute was enacted. It allows you to modify that pooling order to apply to future wells. So we had to come in and pool these wells.
And is it an XCL well?
You
That
guys
was
all know.
the original well was drilled by Axia, but it is an XCL well. Yes, sir.
All right. Well, that's all I have, the questions I have. So your next witness, Mr. Mail.
Thank you for that. Mr. Gravy, can you hear us all right?
Yes, sir.
I'm gonna do same kind of thing with Mr. Anderson, just get some quick information on him and just turn you over for questioning. Can you state your name and spell your last name and business address for the record?
Sure. Mark Gravy, Graeve, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay, and we've got your resume on file. Can you just remind everyone your job title and your responsibilities as they relate to this unit?
Sure. I'm the EVP of Reservoir and Development. So the planning and development of wells in the unit, how many, and the timing of their development.
And I'm assuming that applies and extends all the way to this drilling unit.
Correct.
Okay. We've filed what's been labeled Exhibit 12, Declaration of Mark Gravy. Do you recognize, have you seen this exhibit?
Yes, I have.
Okay. And are you familiar with the allegations that it contains?
Yes, I am.
Did you execute it or cause your counsel to execute it on your behalf?
Yes, I did.
And finally, is there any changes you would like to make to that, or does that declaration conform to your full, accurate, complete testimony?
Nope, no changes.
Okay. Couple summary questions before I turn you over for questioning. You've been recognized as an expert again in petroleum engineering, reservoir engineering in this cause. Is your expert opinion that the actual costs incurred in drilling and operating the thing in wild wells identified here, and is reflected in Exhibit 10 are fair, reasonable, and necessarily incurred?
Yes, I do.
Is it your expert opinion that each of the thing and wild wells was quote unquote economic to drill at the time it was drilled, as that term is utilized in the 139-140 order?
Yes, I do.
Okay. And finally, do you believe that the risks discussed in your declaration and the exhibits on file justify the requested risk compensation award?
Yes, I do.
Okay. With that, I don't believe I have any further questions for Mr. Davey, and would welcome cross-examination.
Division?
The division has no questions, Mr. Green.
Okay, let's move on then.
Okay.
The division, oh, are you?
Oh, no, sorry.
Okay. The division has filed a response of notice of non-opposition to the request for agency action dated September 10th, 2024. Therefore, it's my understanding that you have no opposition in this matter. Is that correct? Okay, is there any, turn time over to you for any presentation you may have?
Based on the testimony given through declaration and the presentation here today, the division is in support of this request. Also, as none of the parties have filed any opposition or appeared here in person, that just supports our support for this request. Thank you.
Thank you, Mr. Haynes. We'll now take closing arguments at this time. We'll start with Mr. Mayo.
Before we do that, if I can quickly, it might be appropriate to move for admission of exhibits 1 through 14 in this cause, and that includes the declarations of the witnesses here.
And is that also the supplemental?
That was in prior.
Oh, I'm sorry.
You're
Get a
good.
little mixed up.
That's okay. There's too many things going on.
All right, that's fine. Okay.
So I guess move for admission of petitioners exhibits 1 through 14 in this cause.
Okay. Vision? No objections. Okay. Okay, we're gonna do closing arguments.
Are they admitted?
Oh, yes. So admitted.
Thank you. Closing arguments will be brief. The fact is, you've seen these guys a lot. We believe that the statutory and regulatory requirements have been satisfied. The requested relief is fair and justified and reasonable based on the circumstances in this case. And based on the answers and testimony given by these witnesses, I would ask that the request be approved here today.
Any more comments, division?
No additional comments.
Okay. I'd like to take a few minutes to meet with Gary for a moment, and we'll be right back.
Live.
Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that Ovintiv, XCL, no offense, has provided sufficient notice of opportunity to the consenting non-owners and those owners identified in the request for agency action that did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that 300% non-consent penalty is fair and justified given the economic and geologic conditions present with these wells, and find that they would be appropriate to impose the requested non-consent penalty. I find got me there. I find that XCL has met its burden of proof to show that they are entitled to force pooling of the named interest and other relief requested in the request for agency action. Mr. Mail, will you prepare the order?
I will happily do that.
I will then present the findings and conclusions to the board next week at a board hearing. Any other comments before we close? Thank you for your participation, and we'll adjourn this meeting at this time. Okay. Before we move on to the third matter, does anyone need to take a moment or two? Okay.
Hang on just 1 second. Let me just.
Okay.
Same witnesses, is that correct?
Same witnesses, and they're both ready to go. So
I love it.
It's fantastic.
Good to go? Okay, thank you. Good morning and welcome. My name is John Rogers. I'm Environmental Manager with the Division of Oil, Gas, and Mining. I have been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, September 18th, 2024, and this is the time and place for the hearing examiner's proceeding for docket number 2024-050, cause number 132-52. In the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Company, LLC, for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River, Wasatch, Colton formations comprised of section 27, 28, 33, and 34, Township 2 South, Range 2 West, Winna Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division staff, legal counsel, petitioners, and the department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Let the record show that no public respondents wish to participate. We will take appearance of counsel this time.
Thank you, Mr. Hearing Examiner. Mitch Mayo of Lear & Lear PLLC on behalf of XCL Resources LLC and XCL Asset Co. LLC, the petitioners in this cause.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
And my counsel is Gary White of the Attorney General's Office. I've received declarations from Mr. Kevin Anderson, Vice President of Business Development and Land, and Mr. Mark Grave, Vice President of Reservoir, both of XCL Resources for this matter, and have reviewed them before this hearing. Both these witnesses have been accepted as expert witnesses in past hearings. Does the division have any objections to these declarations or in these individuals being accepted as expert witnesses today?
No objections.
Okay. They are recognized as experts in their particular field of study and work for this matter. Mr. Mail, witnesses present?
They are present and they seem to be ready.
Okay, can we swear them in this time?
Please raise your right hand to the square. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you.
Okay, we'll now proceed to Mr. Mail for your presentation.
Thank you. The board and the hearing examiner by designation have jurisdiction over this cause pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the requested issue here today was sent by certified mail to all known parties to be pooled who had valid addresses, and was also sent by regular mail to all other production interest owners within the drilling unit at their last address disclosed by the relevant county records or by XCL's internal records or searching. The request was also mailed to all relevant federal and tribal agencies, the BLM, SITLA, DFFSL, due to mineral ownership within the drilling unit. Finally, notice was provided to additional owners via publication, as authorized by the board on August 15th, 2024. Notice of the filing of the RAA was also, and this hearing was also duly published in the Uinta Basin Standard on August 28th, the Deseret News on August 30th, and in the Salt Lake Tribune on September 1st, 2024. On September 10th, the division filed a response, the Division of Oil, Gas, and Mining, I should say, filed a response expressing no opposition to granting the request pending the witness testimony and presentation of evidence here today. I'd like to remind everyone, as we just heard, no other objections or responses were filed, and there are no members of the public here today to contest this matter. A brief summary, this cause involves the compulsory pooling of a drilling unit established in cause number 600-04 for Lower Green River Wasatch production. This unit is comprised of the entirety of sections 27, 28, 33, and 34 in Township 2 South, Range 2 West, USM in Duchesne County. Cause number 130-21 subsequently reduced the heel-toe setbacks to their current 100 feet. In accordance with these two current orders, XCL drilled and has begun to produce from the 2 Thing wells identified in the request for agency action. Several owners of undivided oil and gas interest in the subject unit and subject wells have refused or failed to lease or otherwise agree to pay their proportionate share of the costs of the well, including the names that appear on page 2 of the request. In addition, as discussed in paragraphs 16 and 17 of Exhibit 11 on file, the declaration of Kevin Anenson, several estates are named to be pooled. Although XCL believes it has leased and voluntarily pooled all successors and heirs of those estates, out of an abundance of caution, they are included because XCL is not aware of final probate orders conclusively distributing those estates.
So that last part again, probate orders what?
Conclusively distributing those estates. To be clear, as mentioned earlier, no responses were received to either the mailed or published notice. As reflected on Exhibit 8 on file and discussed in paragraphs 29 through 31 of Mr. Anenson's declaration, the weighted fee landowner's royalty as of the date of spud of the first Thing well is 16.499796%. And with that, I'll begin with my examination of you, Mr. Anenson. Can you please state your name and business address for the record, Mr. Anenson?
Sure. Kevin Anenson, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. And your position with XCL and as it relates to this drilling unit?
Sure. Vice President of Business Development and Land with responsibility over this drilling unit, amongst others.
Okay. Are you aware of what's been filed as Exhibit 11, the declaration of Kevin Anenson?
Yes, I am.
Have you reviewed the allegations made in that declaration?
Yes, I have.
Did you execute or cause your counsel to execute this declaration on your behalf?
Yes, that is correct.
Okay. Does this declaration constitute your full, complete, and accurate testimony here today?
Yes, it does.
Okay. So there's nothing you'd like to add or clarify to that declaration before we start?
There's nothing else I'd like to add.
Okay. Just one question. You've been recognized as an expert in petroleum land management, again, in this cause. In your expert opinion, do the terms and conditions of the JOA that was submitted as Exhibit 7, are those fair, reasonable, and justified, and in keeping with other JOAs you've entered and see in the Uinta Basin?
Yes, that is correct.
Okay. With that, I don't have any further questions for Mr. Anenson. I'm going to turn him over to the division or hearings.
Yeah, Mr. Anson, similar question to before. Exhibit 14 contains the return receipts. There's 3 parties not on there. Craig Miller McFarland, Wesley Smith, and Daniel Smith. Can you please confirm for the record that the compulsory pool parties that were on the certificate of mailing that are not included on Exhibit 14 were mailed through certified mail notice of this request for agency action?
Yes, sir, that is correct.
Thank you. I do have another question regarding the parties that are being pulled in this request. They are similar to the last request. We've added sections 27 and 34. Were there no additional parties in sections 27 and 34?
That is correct. We title actually in 27 and 34 is a lot cleaner than the title in 28 and 33. So we did not have any additionals.
Okay, great. Thank you. And lastly, sorry, again, similar to the last matter, we don't have a date. I don't see a date of first production, so we can just make sure that's included in the proposed order.
Of course.
And then going back to, in your testimony, you indicate that addresses were from a November 2022 title opinion. Could you please explain if any efforts were made to update those addresses when you sent out a notice of this proceeding?
Sure, absolutely. We've taken the title opinion, we've run everything forward. We looked through the records of Duchesne County. We also looked through LexisNexis, Anywho, White Pages, any source that we can get our hands on to make sure that we've got the right addresses so that we can answer these questions and properly pull everybody into our best due diligence.
All right, thank you. No further questions.
One question from me. I noticed here there's 2 companies involved here, XCL Resources and XCL Asset Co. I know in the writings here it says sister companies. Could you explain to me what the relationship is and what?
Sure. So, yep, of course. XCL Resources manages the assets owned by XCL Asset Co. So that's just the difference. All the assets are held in the Asset Co. And then up here, you've got Resources, which is where actually the employees live.
Okay. So Resources, who manages the reservoir then, and the production?
Well, XCL Asset Co. is the identified operator in the division's records. Correct me if I say something wrong, Kevin.
That's right.
The designated operator of these wells. And essentially what he's saying is corporate structure wise, beyond my brain's capacity to understand, it makes sense for them to have, instead of have XCL Asset Co. have employees that operate, they've set up a sister entity, XCL Resources, that is essentially all the employees that manage the operations on behalf of XCL Asset Co., if that makes sense.
Yeah, what you'll find, and for as long as I've been doing this, even with the other companies, you've got like XCL Holdings sitting up here, and then beyond that, you've got XCL Resources, and then you've got XCL Asset Co. The assets live in XCL Asset Co. Then you have an MSA with Asset Co. That manages every asset and also where the employees live.
Okay.
And MSA is a master service agreement, just a big agreement that you use for vendors.
Okay, no more questions for this witness.
Thank you.
Yeah, with that, Mr. Gravy, last couple minutes with you, if I can. Can you please, again, state your name and business address for the record?
Sure, Mark Gravy, Gravee, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. And you testified earlier that you are in an earlier matter, you are the EVP. Can you tell people what that means and your job as it relates to this request?
Sure. I hold the title EVP Reservoir and Development, and primary responsibility is determining how to develop the resource, how many wells, when to develop it, where to put them.
Okay. Are you familiar with what's been filed as Exhibit 12 in this cause, the declaration of Mark Gravy?
I am.
Do you recognize it?
I do.
And have you read and reviewed the allegations? Are you familiar with the allegations that it contains?
I have.
Okay. Did you execute it or have cause your counsel to execute it on your behalf?
Yes,
And does that declaration constitute your full, accurate, and complete testimony here today?
it does.
Okay. If there's anything you'd like to add or clarify, please let us know that as we go. Just a couple questions before I turn you over to the division. In your expert opinion, you've been recognized again as an expert in reservoir petroleum engineering. In your expert opinion, do the actual costs of the two Thing wells, as reflected on exhibit plan on file, are those costs fair, reasonable, and necessarily incurred?
Yes, they are.
Okay, and in your expert opinion, was each Thing well economic to drill as that term is utilized in the 600-04?
Yes, it was.
Okay, finally, the risks discussed in paragraph 14 and the exhibits on file, do you believe those justify the imposition of the requested risk compensation award?
I do.
Okay. With that, I don't have any further questions for Mr. Gravy and turn him over for cross-examination.
Division?
Division has no questions.
Okay. I noticed in here that the P&A cost is at 100,000. I realize that's an estimate. Have you P&A'd any long laterals out there at this time? Or I mean, they're so new, you probably don't want to be doing that, but has there been any kind of?
I can't imagine.
We have not, no.
How's that 100,000 you come up with that? Is that just an estimate, or other companies or other areas in the states have done it, or is it just best guess at this time?
We've plugged and abandoned vertical wells. I would say on average, it's been a little more expensive than $100,000, but they tend to be more isolated rather than a pad of multiple wells that'll be abandoned at the same time. So reconciling the differences there is, we think it'll be a little more affordable when you abandon a pad in the future that has 10 wells on it versus one well kind of independently.
So the primary cost in abandoning a horizontal well is the vertical portion of it?
That's correct. Isolating the different strings with cement and creating barriers.
Okay. All right. Thank you. Turn the time back over. Let's see.
At this point in time, it would probably be appropriate to move for admission of exhibits on file. I would like to move for admission of exhibits 1 through 4, corrected exhibit 5, and exhibits 6 through 14.
Okay, so admit. Well, do you have any comment on that?
No objection.
Okay, so admitted.
Thank you.
Okay.
I'll close out of turn if that's all right. XCL's position is the statutory and regulatory requirements have been met, and that the relief requested is not only fair and reasonable and justified under the circumstances, but routine and necessary for the operation of their business. Based on the declarations and the testimony here today, I would simply ask for approval of the request as pleaded.
Hey, I didn't give you opportunity to present for.
So good.
You all right with that?
Yeah, and as much as no parties have filed.
Okay, and I read your
protest, and no one's showed up to object. The division is in support of this request.
Okay. Well, at the time, I'd like to talk with my counsel just a few minutes, and we'll be right back.
Perfect.
Roger says so.
We got everyone back? Okay, you admitted your exhibits, so. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that XCL has provided sufficient notice of opportunity to the non-consenting compulsory pool owners, and those owners identified in the RAA did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find the 300% non-consent penalty is fair and justified given the economic and geologic conditions present in these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that XCL has met its burden of proof to show that they are entitled to forced pulling of the name, interest, and other relief requested in a request for agency action. Mr. Mail, will you please prepare the order?
I will, and I'll try and get a draft of it by the end of the day tomorrow for review.
Okay, I then will present it at the board's meeting next week. Are there any other comments before we close? I appreciate your involvement and we'll adjourn this meeting. Oh, did you have one?
Thanks for he's just still interested.
Thank you. You have a great day.
Yeah.